They mention item 1 to 88.
My lord, I beg pardon, my lord. Item number 4, my lord.
4.
My lord, kindly adjourn this case taken up any other dates.
Huh?
Kindly adjourn this case. I want to file an amendment petition in this regard.
Adjourn it on request.
My-
Item 9 to 21. 22 to 29. 30 to 39.
Item 38 on behalf of Mr. Jagannath Patnaik, Senior Counsel, Mala, and let it come 1 week after his due to his personal inconvenience. And tomorrow to continue, Mala.
8, huh?
38, Mala.
Okay.
And tomorrow to continue, Mala.
Yes.
31 days to withdraw.
31 withdraw. Yes.
40 to 45.
Item number 31 on behalf of Mr. Bari. Is 1 week after 31. Our similar method होची 10 week 23 out ଅଛି.
Okay. 41 B. 41 on request. 41. Yes.
41 like the similar method ଅଛି.
Yes.
56 to 53.
My lord, 47. In the council, 47 may be available to get on that.
40?
47.
Okay.
March last week. Stay on.
Okay. Adjourn, huh? Okay. On request.
Interim content.
Yes.
54 to 56. 57 to 63. 64.
Lordship, item 6, the informative suffering of viral fever, Lordship, taken up next week any time. There is no entry order.
6.
6.
Okay. Item 6.
May I pardon you, sir? Item 2 and 3, man.
Yes. What happened?
Can I take 1 week after or 2 weeks after?
2 and 3 we got you. Yes.
Item 1.
Lordship, the Lordship, in this case, Lordship has directed the
Yes.
State Council that the receipt of the amount by the informant, Lordship, in this case, that petitioner was working as a GRS. He is a physical handicapped person. There is allegation of misappropriation of 10,800. But as per the statement of everybody, that amount has been wrongly transferred to some of the workers who GRS workers, some of the Pradhan Mantri PMMGNS workers.
Okay.
They are working in the muster role.
Okay.
तांका account को भूले पड़ेइतला बोली.
But you are seeking, you are challenging the cognizance order.
Lordship, that instruction थे payment दे जाइची भूले पड़ेइतला बोली थिला Lordship. सेटा.
Whether it is deliberately or inadvertently, that is, how can I?
Lordship, one witness statement, 161 statements have been categorically stated. Bhul was
Where is that? Show me.
And also,
Where is that? Let us see the charge sheet. Rashmi Ranjan, Florida.
page
What
38, page
you are
39.
working as what?
GRS, ग्राम रोजगार सेवक.
Okay. Show me the statement.
Page 38 and 39.
38, huh?
Huh.
Okay, read it.
May I read?
Yes.
ମୋ ନାଁ ପ୍ରକାଶ ଦାସ 45 ବର୍ଷ 3/3/2022 ତାରିଖରେ ଆପଣମାନଙ୍କୁ ମୌଖିକ ବୟାନ ଦେଉଛି କି ବିଲିକଣା ଗ୍ରାମର ବଳରାମ ସାହୁ ସ୍ୱର୍ଗତ ନିରଞ୍ଜନ ସାହୁଙ୍କୁ ସରକାରଙ୍କ ତରଫରୁ ହିତାଧିକାରୀ ପ୍ରଧାନମନ୍ତ୍ରୀ ଆବାସ ଯୋଜନା ଅନୁସାରେ ଘରଟିଏ ମିଳିଥିଲା। ସରକାରଙ୍କ ନିର୍ଦ୍ଦେଶ କ୍ରମେ ସେ ଘର କାମକୁ ଠିକ ସମୟରେ କରିଥିଲେ। ସରକାରଙ୍କ ତରଫରୁ ହିତାଧିକାରୀ ହିସାବରେ ତାଙ୍କୁ ଟଙ୍କା ନ ମିଳିବାରୁ ସେ କେନ୍ଦ୍ରାପଡ଼ା କଲେକ୍ଟରଙ୍କ ନିକଟରେ ଅଭିଯୋଗ କରିଥିଲେ ବୋଲି ମୁଁ ଶୁଣିଥିଲି। କେନ୍ଦ୍ରାପଡ଼ା ଜିଲ୍ଲା DRDA ପ୍ରେଜେଣ୍ଟ ଇଞ୍ଜିନିୟର ଦିଲ୍ଲୀପ କୁମାର ପରିଡ଼ା ମହୋଦୟ ଉକ୍ତ ଘଟଣାକୁ ଇନକ୍ୱାରି କରିବା ପରେ ଜାଣିବାକୁ ପାଇଲେ ବଳରାମ ସାହୁଙ୍କୁ ମିଳିଥିବା ଟଙ୍କାକୁ ପଞ୍ଚାୟତରେ ନିଯୁକ୍ତି ଥିବା GRS ସସ୍ପେଣ୍ଡ ଅନ୍ୟମାନଙ୍କ ଆକାଉଣ୍ଟକୁ ଭୁଲ ବଶତଃ ଟଙ୍କା ଦେଇ ଦେଇଥିଲେ।
ଭୁଲ ବଶତଃ।
ହଁ।
ଭୁଲ ବଶତଃ।
ଭୁଲ ବଶତଃ।
What about the other
and next also same thing 39 page 39 also Sudhakar Raut, he has also stated ଅନ୍ୟମାନଙ୍କୁ ଭୁଲ ବଶତଃ। ଅନ୍ୟମାନେ means Lordship,
it will be ଭୁଲ ବଶତଃ।
ଭୁଲ Lordship, in that case most one beneficiary is Balaram Sahu.
But see, one of the witnesses, Kalpana Raut, He said, nahi, he is also say, counter bull ବସତୁ ଟଙ୍କା. the-
ଭୁଲ ବସତ ଅଛି
Yes,
ଭୁଲ ବସତ ଯାଇଛି
all of them are saying.
Since the amount has been credited to other account.
ନାଇଁ, that is what ଭୁଲ ବସତ ହେଇଯାଇଛି ବୋଲି କହୁଛନ୍ତି.
ସେ କାହାକୁ ଦେଇଛନ୍ତି ବାହାର ଲୋକ କେହି ନୁହନ୍ତି
Huh?
That objection case can.
And this mistake can happen in the official functioning. All the witnesses are saying भूल वसत ही.
It's not case of by mistake, intention.
no intention
So anything, any witness have said they intentionally it is.
Only it can be proved.
That's right, but how the investigating officer arrive at a conclusion that it is deliberately, if the witnesses are saying it is भूल वसत,
All this can be laid.
that is a general principle. But you tell me the IO has to file the charge sheet on the basis of the material. IO doesn't have any opinion of his own. He is writing a judgment. IO has to say whatever the evidence has come on record. If the evidence says something else, can IO substitute his opinion?
Beneficiary to pattern. In absence of beneficiary.
Huh?
In the ghost property amount.
So then the IO has formed his opinion. He doesn't have the right to do that. You have to, IO has to only see the evidences. On that basis, he has to file the charge. If the evidences speaks otherwise, whether IO has a right to give an opinion, no, it is deliberate. You examine it. Examine it if you have any evidence. I am just issuing notice. Examine it. Okay. Issue notice. Yes. We'll see.
already notice ଯାଇ notice ଯାଇଛି notice ଯାଇଛି instruction
Notice ଯାଇଛି ଆପଣ ଇଏ କରନ୍ତୁ.
Beneficiary to.
Huh?
His appearance.
No, whose appearance?
Program sum was received.
You implead, huh? Implead, Bolram.
okay
Okay. Simply implead Bolram. So, Mr. The learned counsel for the petitioner seek leave of this court to implead the informant in the present case in the opposite party number 2 within a week. Issue notice to the newly implemented opposite party number 2. Written will within 2 weeks. Release the matter for hearing. Interim order to continue. Yes. Yes. Implead, huh? Yes.
And fine.
Yes. Pass over. Okay.
Item 7,
Yes. 7. Pass over. Yes.
item 8,
that's okay
Case 1/24 filed by the CRTC. And pending good structure recover. That is the prayer.
Early, what is it? Opposite party to so cause as to why he shall not be directed to dispose of this case. What is this case? 133 proceedings. The petitioner is seeking. When was it initiated?
That is 1/24 laws. That's obviously file is.
Right on. Petitioner in this petition is seeking direction to the opposite party number 1. That is the sub SDM Bhanjanagar for disposal of the disposal of which case? Miss 1/24 expediency. Expediency. He has regarding to the reasons stated in the application. The petition is allowed. The opposite party number 1, the subdivisional magistrate Bhanjanagar is directed to do well to see that the miss case number 1 of 2024 placed in annexure 3 to the present petition is disposed of as expedition is possible. With this observation, petition is disposed of. Yes.
Item 9. If you not to tell the case, where it is local also of state. The honest High Court said consider bail application include the lot of past in case of that is a.
Fancy.
Next person in this case, the present person already approached to the court, the court has to be checked is the pay. Right, APS number 6499, it's certain events and damage, that not can comply. But now complete an application to directly learning session that consider legal
Petitioner, in the present petition, petitioner is exploring the following relief, prayer relief, following relief. The prayer made in the present petition is vague, and hence no direction is necessary to be made. Mr. Mohantil and counsel for the petitioner state submits that the petitioner had already approached this court by filing ABPL number 6499 of 2022. The coordinate bench of the court by the order dated 6/7/2022 has disposed of the application inter alia directing the petitioner to surrender and move for bail before the court below within a period of 4 weeks. 4 weeks. 4 weeks. However, the petitioner has not complied with the order of the coordinate bench dated 6/7/2022, rather filed the present petition. Therefore, I am not inclined to entertain this petition. However, the petitioner is given liberty to avail the benefit of the order dated 6/7/2022 passed by the coordinate bench in ABPL number 6499 of 2022 and surrender before the court with on or before 20th of March 2020 and resort to the remedy available under law. If he moves and it is open for the petitioner to raise all the points before the court below while pressing the bail plea, and it is expected that the trial courts will deal with the same deal with the same on its merit by taking into consideration the judgment of the Honorable Supreme Court in Tufan Singh versus State Opposition. So, yeah, these observations petition disposal. Yes.
And then
Yes, sir.
This is actually question of a case, but these sections are very relevant actually. Provisions under which, then I shall go into the fact. First, I shall show under which sections I am implicated. Section 399. And
Yes.
another is section 402. But
No, you are challenging what? The
I'm challenging the actually proceedings
The
against me,
entire
the trial
Okay.
proceedings.
yes.
Actually, in 402, the 402 section says that assembly for the purpose of commenting dacoity.
Yes.
And 399 is making preparation to commit dacoity. Nothing has been done, it's preparation. So assembly for the purpose of committing dacoity, for that reason,
It's a preventive kind of section.
a preventive kind of section.
Yes.
But what is the requirement is that, moreover, at any time after passing of this act, shall be one of 5 or more persons. Minimum is 5 or more. Assembled for the purpose.
But that is a dacoity condition. Dacoity for that 5 or more. Yes.
Minimum 5. So what happened here? The charges are framed against 5 persons. The trial was split. Split trial for 3 and another 2. In that split trial for 3, one subsequently didn't come and order came for 2. That order is of 2019. Final order. Final. Then they acquitted.
You say that 2 of them have gone.
Gone. So what? Where is the 5? Where is the 5?
What is it?
Where is the 5? So other cases.
No, those things are all right. But how will you sustain the charge if 2 of them have gone? Yes.
And earlier this petition approached to the Honorable Court for against the order of imbue. This Honorable Court, subject to deposit of 3,000, allows them to surrender and go on paying the loss. My response is if the person who is acquitted the presentation is not comes on similar footing also, because presentation.
No, you are asking general. You simply what he says is for Dokaiti, preparation for Dokaiti, 5% is minimum. Wrong, right, whatever. He's a very bad man. It's all right. But two of them have, out of five people you have charge sheeted. Out of five, 2 people have faced the trial, they have been acquitted. If they are acquitted, now it is reduced down to 3. Then how will you sustain the charge? That is what he says. He's a very bad man. It's all right.
Is the presentation conduct is very.
My conduct is good.
So we can't decide a case on the basis of his conduct, on the basis of material. How will you sustain? You just see, if you have any judgment, if 5 people were initially put forward and eventually one is discharged or one is acquitted, then 4 remains. Since initially 5% were there, you can sustain the charge and can proceed. If you can get some judgment, very well. I am just issuing notice. Issue notice.
My proceedings may be stayed for the timing actually till it is decided. Actually, otherwise in 402 I shall be convicted for the way. And it is a 2019 judgment. It has not been appealed. 2019. The order of the trial court is of 2019. They have accepted it.
See the judgment. See the judgment is 2019.
Yes. They have not.
Why you become wiser at this stage?
Huh?
Why you become wiser at
No, my trial started recently.
When?
Actually, when this honorable court granted bail to me, then I surrendered after that, and that has been my trial.
Okay,
My trial are in the initial.
Okay, you move an application. If application,
It is there. Application is there.
No application for adjournment. If such application is made, the same shall be favorably considered. You move the application before trial court that for adjournment.
Obliged.
Yes.
Obliged.
Yes. Huh? Issue notice, he will file this. And get this is a legal issue. You must get some judgment. Interesting issue. Let us see.
Your Lordship, item number 5 may be taken after 2 weeks. Item number 5. First.
Acha.
Oh, please, Your Lordship.
May I please, Your Lordship? May I beg your pardon, Your Lordship?
Madam,
May I beg your pardon, Your Lordship?
let us go in ascending manner, not in descending manner. Okay. Wait.
Pardon.
I'll take it up. Otherwise, what I'll do is I'll start from the last matter and I'll come to item 1. We should go in ascending manner. Okay. Wait. I'll take it up. Yes. Are you seeking adjournment, by the way? Is he seeking adjournment? Are you seeking adjournment?
No.
Okay. Then you wait. Okay.
My lord, in view of the compromise report, medicine report of the Honorable High Court of Orissa Medicine Center under annexure.
1 minute. Since Mr. Padi is there, Mr. Padi, I have a small issue with you. What had happened is there are few first appeals.
Yes.
Railways and all. Generally, they come, that matter is settled.
Yes.
Okay. I believe the lawyers, they even to the extent that they correct the in pencil,
Yes.
they correct the party name and all. I accept it and pass
Just believing that it's right.
believing it to be correct. But subsequently, your junior lawyer came to my chamber and said that, sir, there are some issues.
Yesterday I had it, my lord.
They don't supply the copy, and it's so dangerous. You tell me, it's so dangerous.
My lord,
So then the practice is what you have the practice. You don't file wakalatnama. You file a memo. I go by that memo as if Union of India has appeared through someone. I believe the other side, and on the ground of settlement, I allow. Subsequently, it is discovered that copies are not supplied
I'm
to Union of
extremely
India,
obliged.
and lawyers are coming and saying,
Or out of his anxiety, he has rushed to this chamber of my lord. I'm extremely sorry. Yes,
no, I got shocked.
yes,
How can it
he
happen?
told me, how can you dare to do so?
Huh?
And you are coming to the chamber
So
and
therefore,
asking
I told them that whenever you file memo, at least Deputy Solicitor General should endorse that this is the memo. Now, anybody can get a memo and say that I am appearing for Union of India, get an order and go.
But officially allotting the cases, what happening?
You know anything can happen.
Yes. Anything can happen. My lord,
Because there is no seal, nothing.
Nothing.
If somebody gives a memo saying that I am for Union of India, I can't check who are the panel lawyers. I accept that. He will take the order and go. Subsequently, we'll discover that that man is not in a panel.
what happening? I'm just only for clarification by court. Generally, one order is going. Then for a second, I'm not blaming anybody. It's a practice what they are doing. They are not serving a copy to our office. Here they are doing this is
And they correcting the order and so that
they getting the order.
settlement.
And in this case, there is a IA for a condemnation delay. He did not elect in the court. It's completely unfair of this practice. Then if court will pass the order. See how mistake is an order is taken with such a mistake. It can be so
Mr. Das was there. He was also shocked. This is-
But I think even the next forever goes against.
My lord, what I'm praying,
Better that when we are
my lord, what I'm praying,
50 state council. I don't know who is there. Memo is given.
This is the problem. Yesterday night he came to me and told me, how are you doing this? Sir, I'm with the anxiety. I've gone there because there is
He's young boy, he said.
that's why I'm praying, my lord. When the council is coming, see me one provision, have you served the copy to the council? You ask the council to present. They are knowingly not serving the copy. That's why in this case also, he has given a copy to here and they are not a copy to IA, to the concerned councils. How can I know? This is the whole problem. They are not understanding the problem of court, the other side also. You know, we are not enemy to them. We are ready to help, but we have to get the copy. Then
Settled, what is the wrong in it?
one notice will go in limitation petition. Then next day we are considered yes, this is the cover case. Let's see my pass nature. What problem they have? I don't know.
Without condoning the delay,
Yes,
how can I allow the main petition
exactly.
on the ground of settlement? I have to pass some order in the condonation of delay. I should know that.
They also believe the law of the counsel for the court also.
You will not believe. I will not open the file also. If the lawyer says that I have settled, okay, give it and.
I know, my lord, since long about his willingness. But once these things are going on now,
please sort it out. Please sort it out.
Yes, what I'm praying, my
Sometimes it will be a disaster.
line brother will be there. And on that day, today, let's issue notice. On next day, I will examine
We
it.
will do it, but wherever there is a
Yes,
delay
yes, I'm extremely sorry, my lord. I am apologized.
but I will suggest you that
New panel has come that don't know the system of working.
so
Also.
therefore, whenever a memo is filed,
Yes.
and it should be endorsed by you.
Obliged.
Side you just
Today onwards, I'll do.
endorse so
Yes.
that at least it is authenticated. The
Yes.
memos are authenticated. Otherwise, it will be misused. Some
Obliged.
it will be misused. That's right. So just simply endorse.
Yes.
All the memos should be endorsed that yes, he is appearing on behalf.
Obliged, man. I'll do this.
Thank you. Sorry for calling.
No, my lord. I'm applying the code that I have given trouble.
4 to 5 cases which we have woken up now also.
There are how many total cases?
15 cases were there.
15 cases, they say that 16 cases, they say that we have settled the dispute. And for Union of India, 5
cases.
5 cases, there is no memo also.
Then a new panels has come. They are not acquainted with the system.
How
So
to
I
go-
enlighten them.
How to go about
No,
this
yes.
matter?
This is a difficult to the court. I asked, henceforth I am to asking a meeting. They will properly feed it. Then you will.
Give those numbers.
Then I will go with the council. I can pursue them.
ଆପଣ ଲେଖିକି ଦେଇଦିଅନ୍ତୁ so that he will correct it. Otherwise, memo ଆପଣଙ୍କର ୟୁନିୟନ ଅଫ୍ ଇଣ୍ଡିଆ ପାଇଁ କିଏ ପିରୁନାହାନ୍ତି ଇଆଡେ ମୁଁ ଲେଖିଦେବି ସେଟଲମେଣ୍ଟ ହେଇଗଲା.
My lord, what I am saying, just like this Apex code system, I make out a printout. My lord suggested, then I could be making.
That's the best way.
I told him that you give it. They are not going and collecting what? What are you doing? Difficult. New panel is coming. Actually, they have not developed
It'll
this
take
system.
little time.
They have a little bit time is required to cook.
Please take it care of.
Sure.
Okay.
Obliged.
Sorry. ଯୋଉଠି ମେମୋ ଆସିକି ସେଗୁଡା କରିବାନି. ମେମୋ
ମତେ ଗୋଟେ ନମ୍ବର ଦେଇଦେଲେ ମୁଁ କରିଦେବି କିଛି ବ୍ୟସ୍ତ ନାହିଁ. Yes.
before lunch you will get that.
My lord, obliged. My lord, on 30 he will be there and he will actually
Yes, the same. I'll issue,
let them file the copy of this IA. Then next date I will.
I'll issue notice on the application of condonation of delay. Let them.
Obliged.
Okay.
My lord, in view of the compromise in mediation report under Annexure 3 before the mediation center of Hon'Ble High Court of Orissa, my lord, that is page 27. The petitioners are making
mediation is successful.
My lord,
Yes.
my lord, the petitioners are now making their payment, my lord. Accordingly, page
Who is appearing for the other side?
complaint case, my
Who is
lord,
appearing?
opposite party, my lord, opposite party, no two, my lord.
Who is he?
My lord, the private party, my lord.
Have they appeared here in the court?
No, they have not appeared, my lord.
And notice was not issued.
No, fresh.
Okay, okay. When the petitioners are seeking passing of the FIR, the Chandrasekharpur PS case number 631 of 2024. 2024. The matter was at the bail at the stage when the petitioner has sought for anticipatory bail. This court referred the matter to the mediation center, High Court Mediation Center. The mediation is the parties have participated in the mediation process, and the mediation has been successful. The High Court Mediation Center, by its report dated 29/1/2025, has placed on record the terms of settlement. When counsel for the petitioner, on the basis of the said mediation report, seeks passing of the entire criminal prosecution initiated by opposite party, number 2, against the petitioner. Issue notice to the opposite party number 2, returnable within a week. 4th, huh? Fourth, yes.
No coercive.
No coercive action in view of the above. No coercive till next date of hearing. No coercive action shall be taken against the petitioners. Yes, my lord.
Problem.
Well,
Yes, sir.
This is an application for quashing the cognizance taken against the in-laws, my lord. In-laws.
In-laws.
In-law. They are all in-laws and they have been dragged in litigation for the last 10 years. They are suffering.
Okay, I'll issue notice.
Ma'am.
Issue notice. You are the mother-in-law. Mother-in-law, father-in-law, or
sister-in-law and all that.
Okay. I'll just issue notice, issue notice. Written rules also. Is there any chance? What is happening in the marriage front?
Marriage, my lord, there is a divorce proceeding pending.
Going on.
Between husband and wife, my lord.
Is there any chance of settlement?
So, the Hon'Ble Court has issued notice and they may appear on 28th. My lord, possibility is there.
Okay, issue notice. Yes.
My lord, date may be fixed so that.
Date will be fixed. Yes. 30. Yes.
My dear Lord, sir. An application challenging the order of 3/2/2025.
Yes.
Passed by DJCOM Special Court under POCSO Act, which are rejected. The petition filed by the accused on section 34 of POCSO Act, my lord.
Yes.
The FIR last on 26/9/2024. The first allegation is, my lord, 376, 2N, 294, 313, 323, 506, 34, 6. The informant is the victim, my lord. But kindly see the FIR, my lord. No,
What was your application?
sir, the
what happened, the input notice accuracy challenging by the present petitioner
Yeah.
on the ground at the date of incident, both the victim and so the accused petitioner is minor. She say alleged for she informed victim and alleged that last since 2014, she kept relations with the present accused petitioner and the FIR is registered as 376-2A and 6 postcard. Registered in 24 September 2024. Unless that 10 years before she established a relationship with that present petitioner. Therefore, the 6 postcode has been added. But the informant is 26 years, accused is 27 years. 10 years before the count corrected, both informant and
Both of them are minor.
34 petition cycle, having no petition, postcode has no petition, does matter refer to the proper
Yes. Yes. Show me the yes. Show me the FIR 10 years back. This is what kind of FIR is this?
The FIR dated is 26/9/2024, but date of occurrence is mentioned 26/9/2014. During the end of the year of 2014, both the informant and both the accused petitioner have been minor. Therefore, 34 petitions filed by the accused petitioner were unanswered. That was rejected. That taken under the challenge.
No, it is a continuing offense. She say, the informant says that since last 10 years, so-and-so is keeping physical relationship with it.
Both have.
It is a continuing offense. It's a continuing offense.
At the time
They
of.
promised to marry. Yes.
My lord, this is the matter, my lord, when today I have filed an IA that is 574. I have
My lord, that is matrimonial dispute case and counter case, my lord. We have filed against 498 and other offenses. In the meantime, my lord, 13 to the divorce allowed, my lord.
13 one IA
31,
and
marriage has
that has
already
been
been
challenged
divorced.
in the High Court, and High Court has also my lord, in MATA, your lordship may come to annexure.
What happened, you tell me.
My lord, your lordship, case and counter case, my lord. So both the cases can be quashed.
My lord.
Now, what happened in that
MATA,
Mata case?
my lord, confirm the judgment, my lord.
Confirm judgment.
Confirm the.
You have no problem in quashing.
No, my lord.
Shall I record your consent?
My lords. My lord, both of the cases can be quashed, my lord. I have filed the 726. That is the first matter, my lord. I have filed this application for quashing of my lord.
On the ground of settlement, you.
My lord,
Marriage dissolved.
marriage has been dissolved, so my lord, the parties are no longer interested to proceed against each other, my lord.
Where is that finding in the?
And case of the year 2015, my lord.
I understand it, but where is the finding for the court below?
Court below.
That they don't want to proceed against each other.
My lord, that is not there.
Then
Trial has not yet
That is
commenced.
not there, my lord. Trial has not yet commenced, my
so
lord.
then why are you not able to understand? You say that they have gone to divorce court where
My lord.
divorce has been granted. Thereafter came to the Mata court.
Mata court.
Mata court they have settled.
No, my
No,
lord.
sir,
Mata
no.
my lord, dismissed. Mata was dismissed. Mata was filed by the wife. Then your lordship may. Then your lordship.
What I'll do is I'll put it at 2 o'clock. Let them
No,
come
ma'am,
home.
2 o'clock.
My lord, that won't be
possible, my
possible.
lord.
To
Give
give
bail.
bail to satisfaction of such magistrate, district superintendent or commissioner, or a direction has been endorsed under subsection 7 under section 71 of the warrant. And I'm sorry, my specs as I that's why I read it.
Foreign person is ready and willing to give the security required by such direction, the magistrate, district superintendent or commissioner shall take such bail or security.
That means a bailable offense, he can give it and go.
Yes, my lord. And he is interested. He has prayed for interim bail.
Yes.
But here is the case, now presentation is inside custody. And now the warrant examination is district Barampur. This is Barampur. So the orders passed by the sub-division.
No, he was arrested and produced before him.
Yes.
He should have been bailable offense. He should have been let off with the bond and all. And in undertaking that, he'll appear there. He was taken into custody. What is this? This is, after all, liberty. I'll interfere. I'll interfere. And I'll set aside this order, that's all.
Oblige, my lord.
What else?
Yes, that will.
I'll
if
set
that will-
aside whatever.
My-
the consequence, right on. What was the offense?
279-304A.
Right, on. Petitioner has been implicated implicated. Where is the FIR?
FIR I have not obtained.
Number you just see, the number also.
Yes, it is there, my lord. GRK's number is there, my lord.
FIR number also you say, tell.
It is not there in the order, my lord.
FIR number at least, in which FIR you are there, at least I should know.
That also I have.
तापर FIR देखला तो 302 थी वो.
It is mentioned in
I
the
know
order.
this is what is happening in this court. I'll pass the order, after I'll discover that in the FIR it is 302.
I am not relying in order. My lord.
No, you tell me the FIR and give me the. I need to know what are the offenses.
Let it come at 2 p.m., my lord.
I'll pass it over. At least. No.
It is custody, my lord.
His liberty is at stake. If it is bailable offense, he has to be out by today. Come what may.
2 p.m. I will obtain FIR.
Bailable of completely wrong order. It is a bailable offense. If it is 379, 304A, he has to be out by today evening. 279, because both are a bailable offense.
And I have prayed for interim bail, my lord. It is there in the.
I'll set aside and do it, but please tell me
My lord,
the
I will
FIR.
inform.
Because danger involved is in the FIR, some other office
Yes.
may.
But the order.
You have not
disclosed,
filed copy of FIR. You have not even written in the petition FIR number. FIR number. What
Warrant
are the
executed in
provisions?
Bhawanipatna and FIR of the district of Ganjam.
That is the reason, Transit.
And the
You are,
accused is
you are
inside
arrested,
custody.
produced before the magistrate. Magistrate should have let you out. But I don't know. Maybe some non-bailable offense may be there.
And it is
Your
of the
client-
year 2018, my lord. That's why.
Sir, your client might have given you wrong instruction without showing the FIR. Get the FIR.
My lord.
Get the FIR.
I will
pass
attend,
on.
my lord, 2
Pass on.
p.m. I will try to get.
Pass on.
May I please, your lordship. This is my lord 138 NI proceeding, NI Act proceeding.
Yes.
I have challenged the Annexure 1,
Yes.
order dated 6/2/25.
You are the accused. You are the accused.
Yes, I'm accused before the court below and office.
I have to, yes, don't mind, I'll have to stop this AC. It's directly coming and I'm not well. Maybe a bit inconvenient, but what to do? Yes.
Well, present person is the accused in the court below and opposite partner 2
Yes.
is the complainant before the court below, my lord. What happened, my lord? I have challenged the order dated 6/2/25, page 11, where the present person has filed the petition as for Annexure 1.
Yes.
Annexure 1, kindly see 91 of CRPC, someone to produce document or other things.
Yes.
Why I am filing, my lord? That has been rejected. Why I am filing? The complainant was examined. And thereafter I have to cross-examine it.
Yes.
While the cross-examine it, I have filed a petition 91 CRPC. Because the documents is very essential to at the time of cross-examination. Why I am saying the scenario is, my lord, opposite party while working as manager in the Bajaj Alliance Corporation.
Yes.
The present petitioner, the present petitioner, my lord, the opposite party while working as Ranjit Patnaik, working as the manager of the Bajaj Alliance Corporation.
Yes.
The present petitioner purchased my lord, policy from Bajaj Insurance. That was policy and reported 7,50,000. Thereafter, my lord, while the amount has to be double, what happened? The opposite part number 2, my lord, opposite part 2, forcefully and undertaken from me.
Your application under section 91 is rejected.
Rejected, my lord.
Just see 91.
Yes.
Can you maintain the application?
Yes, my lord. It clearly mentioned whenever any court officer in charge of a police station considers.
You are not a court.
No.
You are not officer in charge. Yes. Next.
No, my lord. No, I am not. What the consider that the production of any document
Yes.
or thing is necessary to desirable for the purpose of investigation, inquiry, trial. I am in trial.
May issue summons
or other proceeding. I am in trial, my lord. While trial, why I am saying the
that's right, but can
yes.
you? The question is, can you maintain an application at 91 in this kind of situation?
How shall I cross-examine it, my lord? It has posted for kindly see the order that Annexure 1 series that posted for argument without giving me chance. I have submitted because I have purchased a policy from the opposite party, my lord. Opposite party while working as a manager, my lord. That insurance policy belongs to my lord, the company, not the personal. Manager was not there, my lord. If forcefully taken undertaking from me and also taken a check from me that has been deposited and that has been disjourned.
I'll issue notice.
Yes, my lord.
Issue notice and you move application for adjournment.
21 tomorrow is date, my lord.
Application for adjournment.
So urgent copy, my lord.
Yes.
In course of day, lordship.
Yes.
Tomorrow is posted, my lord.
Today is that.
17.
May I please, your lordship? The person has been convicted, arrive for 2 years, and to pay fine of rupees 50.
Admit.
My lord.
And realization of
409.
Fine, my lord.
I
And
beg
bail-
pardon, my lord, I am appealing through virtual. BC.
Yes. Mr. Das. Okay.
Oblige.
Oblige, man.
18.
On behalf of Mr. Jena, kindly taken some other day.
Sorry?
Only one round of before times, that's where we like now. So this is all in setting a place to know, remember, even in the absence of a candidate, we had also like that.
Lordship, Passover. I need Passover. He may conduct.
For every ground, we keep on moving application and coming in picture. Yes. Yes.
19.
Yes.
May I please? This is a Belgium matter. Bail has been granted on 27th June 2023 and NBW has been issued on 9th August 2024.
24. Okay. I wonder.
20.
Repeat it. Switch on.
December 2024, my.
Yes.
21.
On behalf of Mr. Behra, Your Lordship. The bail was granted by this Hon'Ble Court by ABL number 8461 of 2022, dated 28/7/2022, Your Lordship. 28/7/2022, my Lord.
22.
My Lord. And NBW was issued on dated 24/1/2024 by the Annexure 3.
500 each.
My
Lord.
22 bail on 7 February 2022 and NBW 21/9/2023.
Okay. 500. Yes.
23.
My Lord, Belgium Metro, my Lord, NBW order dated 12/11/2021, petitioner release on bail 10th July 2012, High Court, my Lord.
Okay.
Regular bail.
1000 each. Yes.
24.
BW issued on
My Lord, item number
13/5/2024, my Lord. And he is in bail, my Lord. That is the anticipatory bail.
Speak little louder.
NBW issued, my Lord, on 13/5/2024, 12/7/2017 bail.
NBW 17.
No, NBW 20.
Okay, 500. Yes.
25.
25, my Lord, NBW on 1000.
NBW
25 my Lord, Belgium matter.
2023 and
Tell the dates.
very my Lord.
1 minute.
2023, my Lord, NBW dated 27/6/2023 and petitioner number 1, my Lord, enlarged on bail on dated 3/5/2002.
Yes.
Petitioner number 2, 3, 4, 5, 6, 7 and 9 on 17/6/2002.
Okay.
And petitioner number 8, my Lord. I am sorry, my Lord. 6/5/2022, my Lord. 2002, 2, 3, 4, 5, 6, 7 and 9. 7/6/2002, petitioner number 8. There are 3 category of bail, my Lord.
Not the date. Wait. NBW 2023, no? 500 each. Okay. 500 each. Where is the FIR? Where is this place? Hon'Ble. Okay. Yes.
26.
Modification.
Item number 22, my Lord.
Sir, I am for the petitioner. I pray for.
22.
Modification, sir.
I pray for the time, sir.
Modification of condition.
What condition? Which condition modification?
My Lord. Yes, prayed, my Lord. Modify original shell deed ROR, landed property stand recorded in name of the petitioner and execute the personal bond like amount कोर्ट इन सेशन प्रॉपर्टी सिक्योरिटी देवा ପାଇଁ ସେ କହୁଛନ୍ତି।
Which is the order? Let us see which
My
order.
Order he has not annexed.
Simply adjourn.
Annex, my lord.
Simply adjourn. Yes.
27.
नहीं, annex question.
27.
That's so moto one.
Huh?
So moto.
Audio LS? अच्छा LS मधुरी लग गई। Okay. Audio alias अजय भंजो होगा तो audio LS अजय alias भंजो हिंदी मजरू डे और ये LS ठीक है कर दियो करेक्ट। Yes.
28.
Dispose of my.
Yes.
Yes,
Can be disposed of.
It can be disposed of. Who are you?
For the affiliate.
Huh?
For the affiliate.
Because this
Yes, Lord, I made a
created
necessary.
no problem.
No, my lord, yesterday's matter, I will explain on when the matter will reach
Okay,
me.
it's all right. You are appearing for?
I am for the respondent claimant, my lord. Respondent number 1.
As you are for insurance company.
No, my lord, I am for
I'm
the
for the
respondent claimant.
insurance
He is for the insurance company.
You have a wakalatnama?
No, it's
He has filed the appeal, my lord. I am appearing in his case. Ma'am.
Then does he have the wakalatnama?
Yes, ma'am.
Because he is going to pay you.
Yes, ma'am.
Where is your wakalatnama?
it's
What is your name?
on behalf of my senior,
What is your name?
Sampark Sampad.
Huh?
Sampark Sampad.
For whom you are appealing?
For the appellant on behalf of Mr.
Arey,
Das.
advocate.
Who
Anupam
is
Das.
your senior?
Anupam Das.
Anupam Das. See Anupam Das. Does he have the wakalatnama? Anupam Das. In both the matter. Anupam Das. What is your name?
Sampark Sampad.
Your name is not written. Sampath?
SAMPARK Sampark. Sampark Sampad.
Write down and give now. Sampath. For Anupam Das. Anupam Das. Wakalatnama chesa. Mr. Sampath, appearing on behalf of Anupam Das, and you are appearing what?
I am for the respondent 1 claimant in both the cases, ma'am.
Mr. Patnaik.
Yes, ma'am.
Mr. D. Patnaik for respondent number 1 conjointly submits that the matter has already been settled in terms of the settlement terms. The FAO can be disposed of. Accordingly, the present order is passed.
My lord,
Okay.
we have another matter, item 60, also same.
60 also. Same order for 60. 60. 60.
Sir, in the item number 20, the delay. There was a delay in item 20. 28.
20 delay. Delay kanno na?
Yes, sir.
Have you said about delay?
Yes, my lord, we have explained in item 28. Then 60, there is no delay, my lord.
60 there is no delay. There is delay kanno.
Here, my lord, your lordship's order is there, ma'am.
Delay, how many days delay?
Sir, in FAO 88 of 24, there is a delay of 58 days.
58.
Yes, your
Delay
lordship.
of 58 days.
And in FAO 379, there is a delay of 74 days.
Huh? Delay of
74 days.
Okay.
No blame.
29.
29, my lord, also can be disposed of, my lord. He is appearing.
Who is appearing? 29.
He is appearing on behalf of Mr. Somnath, sir.
Delay is there?
Yes, your lordship. There
How
is a
much
delay
is-
of 32 days.
Huh?
32 days delay.
Same, 29th Amendment. 29th, 70?
32.
32 days. ठीक है, मिला 30. प्रथम जहाँ लिखा है ना,
On behalf of Somnath.
Huh?
On behalf of Somnath.
I on behalf of
Somnath.
Somnath. Somnath, yeah? संपत ये लोग संपत ना कौन सा नाम है डिफिकल्ट फॉर सोमनाथ हाँ संपत फॉर सोमनाथ ठीक है यस
30, my lord, there is delay of about 48 days, my lord. Yesterday I have served the copy, extra copy, my lord, because you have served in the counter, my lord.
Shall I condone the delay?
Yes, ma'am.
It will be 30 so and so appear for the Union of India and files memo to that effect and memo to that effect. I number 1047. So 1047 of 2024 for the reasons stated in the application for condonation of delay of how many days? 48 days.
48.
In filing the appeal has been is condoned and condoned. The counsel for the union have not seriously opposed the same. The parties have certificated to Tapal Theodore. What is that order?
Madam, yesterday you have provided.
What was the item number?
41.
41 item number. ये पता है? तार ऊपर जुड़ी है. 41 है. ताल रो 40. Carefully करियो. Stop no पकड़. Yes.
Problem.
32.
My lord, I am for the office, pass over. Yes, sir.
Challenge the order of cognizance in a case on section on the ground that the petitioner who is the accused person is staying outside the jurisdiction of the court which is conducting the before whom the case is pending, my lord. On that score also by previously case was also has also been
First show me that
the
you are outside,
my lord.
yes.
My lord, may kindly see Annexure 1 and 1 series page 6.
Yes.
The first title of the complaint petition.
Santosh Kumar Muni.
Santosh Kumar Muni has instituted the case and is staying at Barampur.
Yes.
And this petitioner is staying Aska. Lakshmikant Sav.
Yes.
Therefore, my lord, the learned court below he should have conducted inquiry on section 300 or 202 CRPC, my lord. That has also been decided there in the case. Also,
it's a 138 case.
Again,
it is a 138 case.
138 case.
Yes.
Also, in every complaint case, including a case on section 138, that has been clarified in case Joseph's case, which I showed on the in that way, and your lord, my lord, has also taken reference of that. The decisions which I have I had shown on that case, my lord.
Yes.
Which
paragraph, sir?
Well, yes, Joseph, paragraph 5, my lord.
Paragraph 5.
My lord.
Yes. Yes.
May I read? Yes. Mr. Raja, learned counsel for the petitioner submitted that the procedure adopted by the learned court below by taking cognizance of the offence on section 138 of NI Act is contrary to establish the procedure recognized under law. He has relied upon the judgment of the Honorable Supreme Court in the case of K.S. Joseph versus Philips Carbon Black Limited and another, reported in 2016-64 OCR Supreme Court 61. To substantiate his submissions, he has emphasized paragraph 6 and 7 of the said judgment, which reads as under. Paragraph 6. On the basis of order sheet of the Court of Magistrate, it has been shown that initially someone's order to be issued to the accused on 5/12/2006 after recording a single sentence that the complainant was present. Since proper steps were not taken, summons appear to.
My lord, the petition is not maintainable. Revision is maintainable. I have given the judgment of your lordship will kindly see. I have quoted.
But I will set aside, I'll send it back, remit back.
But revision is maintainable. CRLMC is not maintainable.
But in this case, CRLMC was.
Sir, bhul.
Last
But
time.
you were referring you.
No, I have said there also I had submitted this judgment of the Supreme
He
Court.
had also
I
told
have
that.
that OLR case. OLR
No,
reported.
Revision means.
Was it your
My lord, I had submitted that
maintainability of it?
That
He has contended revision.
2024 2 OLR Supreme Court 721.
See, I'll tell you the problem. Suppose I'll go by you are correct.
My lord.
Then I'll ask him to file a revision.
Yes.
Revision for set aside author jibo.
No.
Author time waste kariya I'll
No,
set aside and immediately cognizance नहीं कि आपनों 138 meter चलिबो. Unnecessary time कहीं खराब करिया आपनों. बुले से काम हो. Time खराब हो. Best remind करके I'll just give 15 days time to consider and finish it up. It is 138 meter.
No. Yet what he says is not a fact because he issued a check. Where can he lodge the complaint?
No, it says 202 procedure is not.
No, that is another thing. That is I can't say I'm not saying anything on. I'm not submitting anything on that issue. But the fact that he submitted that because he belongs to Berhampur and case is filed in Aska, that is not maintainable.
No.
That is not acceptable.
No, say kotha mo point.
He has said otherwise. He said 202 procedure is not complied.
That is the only point that he is raising.
That's the only point.
Only point he is raising.
The better I'll set aside and I'll fix 15 days and no cognizance नहीं आरंभ कर दे सरला का अपनो revision रे जा ये दिन सब time काहे खराब करिया
आज्ञा ସେ ଆର କେସରେ ଆପଣ ଯାହା ଦେଇଛନ୍ତି ସେଟା
ସେଇଟା ତ ସେଇଆ ଥିଲା ଗତ ଥର ବି submitted like that also.
Yeah, I have not fixed the time, but I'll fix the time now because complaint. Which year complaint?
Number 23. 23 recent complaint. That is.
आपनो आइने मिलियो कोनो?
नहीं.
What are you going to get? Cognizance will be taken. Procedural defect.
One thing cannot be done beyond the procedure, my lord. That has also. That.
See, again the cognizance will be taken again.
Again will be taken.
What did you achieve out of it? What is the check amount?
Again.
Check amount? What is the check amount?
9 lakh something. They say.
Why don't
other police have the checks were stolen? All these things they have to prove, my lord.
But why don't you settle with the dispute? Will you settle? I'll send it to mediation. Better that you settle with the dispute. No. You want to face it? Face it. I know. Petitioner is agreed by the order dated 29/6/2023 passed by the learned SDGM in 1cc number 217 of 2023, initiated by the opposite party for alleged offence committed by the petitioner under section 138A9 Act. Learned counsel for the petitioner has precisely challenged the order only on the ground that the procedure contemplated under section 202 CRPC has not been complied by the court below while taking cognizance of the offence. So he has relied upon the judgment of this court passed in CRLMC number 2138 of 2024, dated 23/12/2024. He has drawn my attention to para 5 and para 5 and para 8 of the judgment, which judgment. Mr. Pujari, learned counsel for the petitioner, vehemently opposed the prayer made by the petitioner on the ground that indeed the present petition is not maintainable. The petitioners ought to have preferred a revision against the impugn order, I have to consider the rival contention of both the parties, and is of the opinion that on the ground of technicality, even if the petitioner is relegated to revisional jurisdiction to challenge the impugn order, the only fallback would be to delay the proceedings initiated by the opposite party under section 138 NI Act against the petitioner. The section 143 bracket 2 of NI Act mandates the cases of present nature needs to be disposed of as expeditiously as possible within the period of 6 months. Keeping in view the mandate of law, I am of the considered view that the technical objection by the petitioner needs to be cured at this stage. Hence, I allow the petition, set aside the impugn order also, and remit back to the trial court to remit back the trial court for affording an opportunity to the opposite party complainant to record the pre-summoning evidence of the initial statement under section 202 CRPC, and the trial court shall proceed in accordance with the law thereafter. In view of the mandatory provision under section 143(2) of CRPC, I am also intend to direct the trial court to do well to see that the entire process takes place as expeditiously as possible, preferably in a period of 1 month hence. With this observation, the petition will be disposed of. Yes, sir.
Lordship, on behalf of Mr. Ponda, pray for Passover, Lordship.
Before.
Modification, my lord. My lord, modify the order to 6/2025. But earlier occasion, my lord, modify the order on 6/2025.
Modification.
My lord. Earlier hitla 6 and the petitioner while producing the certified copy of this honorable court, the law and court below while verifying the father's name of the petitioner mentioned as Daniel Lag. But my lord, the order said Daniel Pradhan. So he suggested that modify the father's name as Daniel Pradhan alias Naik alias Chakrabarti Pradhan.
Already I have done it, na?
Earlier my lord Naik କରିଥିଲେ. Earlier my lord Naik modify କରିଥିଲେ.
I am not able to understand. Odia kon.
Mala earlier occasion my lord 6/2025 रे modify କରିଥିଲେ हजूर.
Daniel Pradhan
Naik କରିଥିଲେ.
Chakrabarti Pradhan.
Mala से produce कला पर से FIR कॉपीटा देखिले. FIR Daniel Naik अछि.
What is you are not sure about your Daniel sometime
order sheet रे मला Daniel प्रधान अछि. FIR Daniel Naik अछि. मते मोर आधार कार्ड से produce कर.
See your cause title.
What title my lord?
You are Daniel Pradhan.
Daniel Pradhan my lord as per order dated impugn order dated 20/9/2020 mentioned as Daniel Pradhan by annexure 3 page 31 my lord. Impugn order NBW Daniel Pradhan कले तांकर order sheet रे same sir cost title लिखा हला. Again
9 you come to page 9.
Page 9
Daniel Pradhan.
Daniel Pradhan.
So why should I correct it? Everywhere it is Daniel Pradhan.
Daniel Pradhan अछि किंतु but my lord page 8 FIR Daniel Naik.
Correct the FIR.
No my lord. Suggested the law and code below my lord. So आधार कार्ड देखला पर कहले तो मेडा करेक्शन करि गनो my lord. Father नाटा
in the FIR if some wrong number has come, can I correct in a 482 proceeding? FIR रे correction करी मु.
No my lord से କଥା मु कोनी. से किंतु order sheet रे my lord Daniel Pradhan लिखले. तांकर order sheet Daniel Pradhan.
I don't know. I can't do it. I can't correct your FIR.
Kala alias कर देले हिजो my lord.
How can in the 482 court change the description in an FIR?
Sir my lord से accept करना दे my lord. So कल correction करी modify करी गनो.
That's a different thing. I can't correct the FIR. You will say somebody, I will write somebody else's name.
My lord, FIR mention as Daniel Naik.
Wrong, right, whatever.
My lord.
I can't correct an FIR.
सेटा मारे मु कोनी किंतु मारे तांकर ऑर्डर शीट रे मारे डानियल प्रदान करी दोछन तांकर ऑर्डर शीट रे.
Then what can I do, sir? You just imagine. Can I correct an FIR?
alias होगला my lord हिजो.
How can I do alias? Somebody else will be accused.
I will file affidavit before the law and court below.
Suppose I'll write alias something, and somebody else will be made accused in the direction of the High Court. If I corrected the FIR,
ମାନେ ଆକ୍ୟୁଜ ଠିକ ଅଛି ଆକ୍ୟୁଜ ର ବାପା ନାଟା ଦେଇଛୁ ଆଧାର କାର୍ଡ ରେ ଭଲ ଭାବରେ ଅଛି
ଆଉ ଗୋଟେ କିଏ ନାଁ ଥିବ ତାକୁ ଧରିକି ପଶେଇଦେବେ ଭିତରେ ହାଇକୋର୍ଟ କହିଛି ବୋଲି
ଆକ୍ୟୁଜ
ଆପଣ
ମାନେ ଆକ୍ୟୁଜ ଜେନୁଇନ ଆକ୍ୟୁଜ ଜେନୁଇନ ମାଇଲର
how can I correct an FIR? I don't understand.
ମାନେ ତାଙ୍କର ଅର୍ଡର ସିଟ୍ ମାଇଲର ଦିଟା ନାଁ ସେମାନେ ଲେଖିଛନ୍ତି
You do something else. I can't correct it. ଆପଣଙ୍କର ପୁରା ପ୍ରୋସିଡିଂ ରେ ଯାହା ଥିଲା I will correct. I have corrected once. Today you are facing because there is a problem in the FIR.
ସେଇଟା ମାରିଲେ ସେ ଅବଜରଭେସନ ନହେଲେ ମୁଁ ତଳେ ସେଇଟା ଆପ୍ଲିକେଟ କରିଦେବି ସେଟାକୁ ସେ ଅବଜରଭେସନ ହେଲେ ହେଇଯିବ
If I will make an observation, it will be more difficult for you. The trial court will not do it.
No, see,
I'll simply say that you are withdrawing to raise this point before the trial court. If the trial court, if you move application, the same shall be considered. If I'll say anything on merit, then your hands will be, petitioner is modification of the order dated 6/1. The present application is application for modification for the second time. The petitioner is seeking modification of the order dated 6/1/2025 regarding the name of the father of the petitioner, the father of petitioner. For the reasons stated in the application, I am of the view that the petitioner should move appropriate application before the trial court instead of seeking the modification before this court. Therefore, the the application is disposed of with liberty as correct. Yes.
35.
Please, my lord. One time file requisite.
Sorry?
One time.
Requisites a person requisite as per the order dated 3/12/2024 has not been filed with the petitioner. Hence, 1 week time is sought. Which is granted. Yes.
6.
Passing a proceeding matter on the ground of compromise.
Compromise.
498 day.
Okay.
Complaint person I filed with Rosipal.
Are they here?
Yes, sir. Both the parties are here.
Snigdharani Dakwa. Ratikant Dakwa. Yes. Only one accused.
Only one accused, the husband.
Yes, Snigdharani, you come this side. Yes.
Malad, it's a case, Malad, arising out of a matrimonial dispute.
Yes.
And the facts of the case, Malad,
498 and 500.
498.
494 is also there.
Sir, take sir. 498, 494, 500 IPC. Malad, here is the case, Malad. Both the parties, Malad, got married in the year of 2005. And both are Malad relations. Mana PC Jio, Mamu Jio, cousin sister, and love marriage, and thereafter, and both the parties, Malad separated since 2008 by document, registered document annexure 5.
What do you want to say?
Malad. Thereafter, Malad, in the year of 2009, the petitioner got married another guy. In the 2013, the private opposite party, Malad, filed a complaint case as against the petitioner, stating therein, Malad, the present petitioners, Malad, got some documents, Malad, some signature documents, and registered the annexure 5. That is the, Malad, facts of the case.
Annexure 5.
Malad 5. Yes. That is registered in the year of 2008. And this case, and in between, Malad, the opposite party, Malad, filed different domestic violence and other cases, Malad, different cases filed. And the present petitioner, Malad, working as a lecturer at Pilan.
Yes, sir.
And my lord, my ground of challenge, my lord, once a registered document, my lord, issued, consent of the both the parties, my lord, after 5 years.
What is this document?
Document, my lord, both the parties, my lord, separated each other, my lord, in a decree of the, document of divorce, my lord.
What is this document of divorce? Before whom?
My lord, Restaurant Authority, DSR, Jharsuguda.
This is how the divorce are granted.
No, Lord. No. Thereafter, my lord, both the my lord, I got the divorce.
Annexure 3.
But thereafter, my lord, the present petitioner, my lord, filed a divorce case before the civil court and got the my lord, divorce already granted. And against that order, my lord, the opposite party, my lord, filed appeal and the appeal is confirmed. And now, my lord, I am not received any notice.
What for document annexure 5 you have created? Both of you have created.
My lord,
So
that is the my lord, crux point. That is the document, my lord. Both the parties I have annexed. Your lordship kindly see page 36.
Yes. Yes.
Page-
Yes, I'm there.
Page 36 of my brief.
I'm there. Yes.
ଆଦ୍ୟ ଆମ୍ଭ ପକ୍ଷଗଣ ଆମ୍ଭମାନଙ୍କ ସ୍ୱଇଚ୍ଛାରେ ଛାଡ଼ପତ୍ର ଦଲିଲ ପ୍ରଦାନ କରିବାର ଏମତି ଯେ
What kind of
my lord, my submission, my lord, before your lordships,
Yes.
my submission, my lord, if a document has been registered before the registering authority,
How I'm wondering how the registering authority has
my lord,
registered it.
Yes.
I issue notice to the registered authority. Who has given this registering authority to register a divorce decree?
my lord,
One by both of you?
Jharsuguda.
Jharsuguda. You might have misled or you might have done it anything. And then the wife and husband will prepare a note and go and get it registered that we have divorced.
My lord,
You
my
reduce down
submission
to
was, my lord, this is
I
it.
may
My
be
lord,
permitted to
my-
place
This is
your-
what I will issue notice right now.
Your lordship.
To the registering officer.
Lordship.
Wait.
Prior to that, may I humbly pray before your lordship?
Both of you are party to all this thing.
Lordship, no, your lordship. The present case before your lordship is challenging a order of cognizance pending against which a revision has been prepared before the learned district judge that has been dismissed with a rescind order.
Well, I have mentioned, my lord.
The order has not yet been annexed in view of a.
My lord, already filed, my lord. This honorable court.
I rely upon the judgment of Honorable Apex Court, your lordship.
And then you should have said that if you file a petition.
Your lordship, para 4. Para 4, page 3, para 4. That the petitioner then challenged the order of cognizance preferring criminal 14 before the learned suspender. Them same has dismissed. I have disclosed, my lord.
Disclose, but you see,
A document has been given, my lord, before this honorable court. While the hearing was going on, my learned senior, my lord, was not there. My learned senior, my lord, earlier was not there.
It is not placed on record. How will I believe?
Yes. Challenge is not to this impugned order. Challenge is to 1cc proceeding.
You challenge this order. Huh?
He has not challenged
You
this
have to
order.
challenge this order. It is speaking order.
Yes, your lordship. Moreover,
You have to challenge
this
this order.
482 is not maintainable in view of this.
See, if you want to aggravate, then I'll have to issue notice to the registrar. How
My lord,
registered?
my lord, my submissions, my lord.
Now,
My
if
submissions.
it come to the notice of a court that some illegality has been done by one of the officer, and is it not the responsibility of the court to call for an explanation?
No, lordship, my
Then it is a
submission.
disastrous consequence.
My lord, my submissions before lordship.
Notaries are doing it's all right. Notary,
My lord.
they can do anything. But you,
My lord, my submission before whether a document, my lord, rightly or wrongly issued. Suppose, my lord, once held it.
Don't aggravate, better you withdraw. Otherwise, I'll have to pass all these things. Why to? Because matrimonial. Otherwise, I would have done it. Matrimonial dispute, if I precipitate it,
Your lordship,
it will not renew to the
My lord, may I submit, my lord?
Withdraw to challenge it.
My lord, may I submit one gote point I କହୁଛି? My lord, ये जो registered document ହେଲା ସେମାନେ challenge they have knowledge, they have filed 2010 ଗୋଟେ DB.
Are you insisting upon that registered?
No.
Then
No, your lordship.
I'll issue notice to that officer and all three of you will go to jail.
I withdraw, my lord, with permission to, my lord.
What is it? Both the wife and husband prepare a note that we have divorced. Chhadapatra higa. And they go to sub-registrar's office and get it registered. Just imagine. What kind of people, what kind of thing you have done. And you will be in trouble, that officer will be also in trouble.
Moreover, your lordship, the self-same petitioner has prepared a decree.
You are also not
Revoke
clean.
petition.
You are also not clean. Don't tell all these things. All of you have done. And because of you are fight, and that officer will be in trouble. So keep it here. Keep it here.
Evidence to body.
Keep it here. Keep it here. He'll withdraw and challenge it. Okay?
During
At the,
whereas he got
at
married.
the outset,
He own
it was
he is admitted.
pointed out by the company, the petitioner is agreed by the petitioner is seeking passing of the criminal proceeding initiated by the opposite party in ICC 1 case number 24 of 2030 pending before the court of DGM for alleged offences punishable under section 494 oblique 498 capital A and 50 IPC. At the outset, the counsel for the opposite party has pointed out that on the self-same grounds, the petitioner had already moved an application before the first additional session judge, session judge by filing criminal revision number 14 oblique 05 of 2013. The first additional sessions judge Sambalpur, by its detailed judgment dated 11/3/2016, have dismissed the revision petition, delving upon the issues raised by the petitioner in minute detail. Confronted with the situation, confronted with this position, the learned counsel for the petitioner submits that he would prefer to withdraw the present petition to seek remedy against the judgment dated 11/3/2016 passed by the first additional session judge Sambalpur in criminal revision number 40/05 of 2030. With the comments and devotion, the petition is disposed of. Yes. Is that clear?
Obliged.
Yes. Yes.
Obliged.
I am the opposite party, my lord. Opposite party.
Who is appearing for the petitioner? There is an interim order.
Item 41 is also 40.
NIAC matter.
40. 1 minute. 1 minute, Mr. Jana. 40. I'll just pass over. Let him come. Pass over. Okay. 41.
May I please answer? 41 also connected matter is one connected matter is there. Criminal Vision 10/2023. Both the matter may can be listed one day. This may be another.
Because you are opposite party.
No, both the
sought
cases
for an adjournment.
Both the cases I am the petitioner. Criminal Vision 10/2023.
Give the number, sir. Give the number.
Criminal discussion number 10/2023. 10/2023. 10/2023.
Okay. Lease this lease the present matter along with this. Okay. Yes. 42.
42.
Here in this case, the petitioner, my lord, this is a matrimonial dispute, my lord. The background of the case in short, my lord, that in 1993, a 125 proceeding was initiated by the wife. That case, my lord, was compromised at 10,000 only. The husband paid that amount. Thereafter, what has happened, my lord? In 2012, 20 years after,
yes,
a case under the Domestic Violence Act was initiated.
Yes.
That case, my lord, was disposed of with a finding that husband has to pay 500 rupees to the wife and another 500 rupees for the doctor.
Yes.
Doctor became major my lord. Thereafter, only wife remained. Wife my lord,
500.
500 rupees. My lord, thereafter, what has happened in the said case, that domestic violence case, my lord, matter was settled between the parties at 25,000. Your lordship may kindly see Annex 4. Out of that 30,000, my lord, sorry, it was settled at 30,000. Out of 30,000, 25,000 was paid. 5,000 only remained as per this Annex 4.
Full and final settlement or monthly?
Yes, yes, your lordship. Thereafter,
Compromise, yes, yes.
thereafter, what has happened? It was settled at 30,000, 25,000 was paid, but on the date of compromise, the wife insisted for 20,000 again, and husband agreed with that. And thereafter, what has happened? Your lordship may kindly see.
Have you paid or not? 20,000.
That amount has been paid in view of the order of by this honorable court. That has been paid. That 20,000 has been paid.
So 50,000 you have paid.
25,000.
Sorry, 25.
45,000.
Yes.
So, my lord, absolutely there is no cause of action, and now NBW and bailable warrant has been issued. That has been stayed, and this order has been passed.
I am for the appealers.
Yes.
Lordship. In fact, no compromise petition was filed before this court. Lordship, can be go to the file. I mean,
This is the order, just
certified
see.
copy, your lordship.
Page 25.
Page 25, Lordship.
Compromise petition.
No, Lordship. It is
You
not
have
filed before this court. The council official must pass the civil order, Lordship.
Sorry?
The presiding officials must pass the civil order, Lordship. Those such petition was filed, Lordship. And it is the instruction of the opposite party.
Now you just simply tell me whether this compromise petition you have filed or not.
No.
At 25,000
It is
rupees.
done outside of the court, Lordship.
But 25,000 rupees have you taken?
No.
You have signed it.
Lordship, judgment to court done to knowledge of the presiding official, Lordship. बाहर कौन कौन सी मुझे जान ले Lordship. It is legislated. It is court फाइल करा का था.
Certified copy आसी
You should be fair enough.
देखो जो Lordship court बाहर लिख दे.
My lord, this another
You have signed it.
Lordship
and it was filed in the court.
Lordship, ଗୋଟେ କାଗଜ लिखି ଦେଲୁ କୋର୍ଟ ବାହାରେ ତାପରେ କୋର୍ଟ ବିନା knowledge ରେ ଆମେ କୋର୍ଟ फाइल टेक कर दो. Again, you got a certified copy.
You where is the proceeding of the court below? Whether in this application, the compromise petition, any order was passed?
No, Lordship.
Show me.
Order has been my lord,
This application was moved when? Application was moved on.
170.
Just see application.
Date is mentioned.
17
17/9/2022 stop रे से endorsement है चीज़ जो stamp
Just see the proceeding says 17/9/2022 certified copy. Both the parties and the learned council present today file a joint compromise petition with the signature of both the parties. Put the matter on search. Then
presiding officer order कौन रहेला Lordship? जो फाइल हैला.
Don't go by that. No.
To my knowledge, Lordship.
This is dishonest.
That is created outside the court and letter filed.
You are present. Your counsel will present. Compromise petition was filed, and 25,000 rupees is paid to you. And thereafter you make
order कौन हैला दियो बोले.
No.
It is the knowledge presiding officer knowledge नेवा का था ये जो petition दा file कर ले Lordship.
Presiding officer only writes this.
No, Lordship.
This is the proceeding. No, what is no?
Petition, compromise petition, Lordship.
Just see the proceeding. Have you seen the proceeding? Certified copy of the proceeding of the presiding officer. He writes that it is presented before him.
Sorry, Lordship.
Just see second proceeding 21/11/2022. Petitioner is present. The advocate of the petition is absent. OP is present. You are present. Advocate for OP is also present. Heard both the sides regarding the payment of the arrears of maintenance. Advocate so has compromised, has settled outside to reduce the amount. Hence, PO is directed to file a citation of reduction of arrears of amount. Everything is there. Everything is there.
Matter has been settled, my lord. Draft.
Yes, you have to just see, this is dishonest.
Initially, in the
What is the
1990s.
interim order? NBW stay is already been granted?
No, sir.
Measure direct the NBW. Where is NBW order to show me? Show me the NBW.
My lord,
That is page your lordship.
my lord, your lordship was 30th January 2023, my lord. This honorable court was pleased to pass an order.
Now the NBW has been issued, you say. Where is that order? I'll say it.
Page 28 रे अच्छे annexure 6 23 2022
My lord, at Annexure 6.
Annexure 6.
Annexure 6, page 28.
28.
Yes, your lordship. 23rd December 2022, that order.
This has been said?
That has been said.
Now I will record everything. You go and tell that all these things to the court.
Yes, your lordship.
I'll say it. Yes. Right on. Right on. It is. What are you challenging now here?
My lord, this issuance of DW and NBW order dated entire proceeding was challenged, that this proceeding cannot run in view of the fact that has been.
Which proceeding you are challenging?
This CMC, your lordship.
66 to up 21.
66
Up 21.
21. But subsequently, my lord, the nomenclature of
petition is agreed by the order dated 23/12/2022 passed by Family Judge Nagar, whereby NBW has been issued against the petitioner in criminal MP number 66 of 2020. Counsel for the petitioner submits that initially a petition application under section 125 CRPC was moved by the opposite party, which ended up by a settlement, and the petitioner agreed to pay rupees 10,000 per month. And he has been making good the payment as per the settlement. Subsequently, the opposite party filed another petition under section 12 of DVA against the petitioner. In the said petition, certain interim order directions were made. When the matter was going on, at that point in time, the parties have entered into a settlement. And moved a compromise petition. The terms of the compromise reads as under page 25, para 2. The certificate copy of the proceeding of the Family Judge Nagar in CRL MP number 66 of 2021 dated 17/9/2022 reveals that the compromise petition was filed before the court below in presence of the parties and their counsel. Certain on the subsequent dates, that is on 21/11/2022, the payment of the part payment of 25,000 rupees as per the compromise has also been acknowledged. Acknowledged. And insofar as the remaining payment of agreed amount of 5,000 out of 30,000 is concerned, the opposite party had insisted to pay 20,000 in place of 5,000. This court, while issuing notice, issuing notice in the present matter, directed the petitioner to deposit 20,000 rupees. 20,000 rupees. The petitioner has also made good that payment. Even then, the opposite party is proceeding with the execution, proceeding with the DB proceeding. Hence, the petitioner has approached this court. Regarding head to the aforementioned, aforementioned, the impugn order dated 23/12/2022 is signed, the petitioner is granted liberty to appear before the court on or before 30th of March 2022, move appropriate application for dropping of the proceeding in view of the development which has unfolded in the present case. If such application is moved, the same shall be considered by the trial court on the basis of the material available on record and the available on record. With this observation, the petition is disposed. Yeah.
Actually,
photocopy, I will solve.
Yeah, please.
May I please?
Yes.
My lord, both the petitioners are, my lord, both the petitioners are ladies, my lord. The present petitioner challenge the order of cognizance. Your lordship kindly glance to Annex 1 or only page 7. Initially, case was registered on section 307 and along with other offences. In which the present petitioners approved the son report and already granted the anti-suit bail. After that, after filing of charge sheet, at the time of filing of charge sheet, IO submitted charge sheet 307 along with the other offences, along with section 3 of the SCST Act, my lord, in which both the petitioners are ladies, they don't appear in the special court. In which I have challenged the order of cognizance. You also kindly glance to the Annex 2.
Where is the charge sheet? Where is the charge sheet?
My lord?
Where is the charge sheet?
That's not required.
Charge sheet, my lord.
You file the charge sheet, how will I know then?
My lord, I have also the charge sheet copy also.
Illinois Counsel for the petitioner seeks an adjournment to place on record the additional document to substantiate his case. Let him place on record the copy of the charge sheet, release the matter. Yes.
the fourth.
May it please your lordship.
44 your lordship.
No.
44 your lordship. May I pray your lordship?
Sorry?
Pray for tomorrow or some Monday lordship.
I will take only 5 minutes. If your lordship feels that his statement would be required, then I would have known.
Yes, tell me that.
Charge sheet was submitted on 181 days. Admittedly, your lordship may kindly first see the statement.
Oh, I know, I remember that. Now.
Madam.
Yes.
So your lordship's question was, if you have filed the bail petition after 1 day, then he would not be entitled for bail. Your lordship will kindly see the order sheet. I had submitted earlier, but I am again submitting. Order sheet. Certificate copy.
Yes.
The order sheet kindly see. Order sheet may kindly be seen.
Yes, sir. 24. Okay.
22nd, it was posted to 4/3.
Yes.
Then on 24th, charge sheet was filed. Petitioner was not present.
Yes.
No notice was given to the petitioner. And 25th was a Sunday.
26th you moved the application.
26th I moved. 25th is a Sunday.
He was in custody. 24th behind his back, it was filed. 25th was a Sunday. 26th, the first available opportunity, moved the application.
Yes.
It is statutory thing. What to do?
I keep in mind that part. So this is very.
What to do? You tell me. You are relying upon some judgment.
Yes, I will say.
And in the affidavit which you have filed, you have admitted this position. You have admitted this position. Come to this para 2. This is filed by
the IO
sub-inspector. Yes. Let's see. You admitted this position.
Yes, yes. Tomorrow,
Yeah?
How? Why tomorrow? He is in custody.
Therefore, I'm taking time.
Who is conducting?
This Jana.
I'll pass it over.
Today is not available. Tomorrow or Monday.
Tomorrow I may not be there. Even if I'm Monday, I'm not there.
Sorry, yours.
There will be no use if there is
See,
a
after see liberty of a some person, the statutory right under 167(2). I'll just pass over, just go through this and let us finish it up today. Go through it, no problem. I'll pass it over.
Yes, sir.
Then otherwise, if you don't do it, we are doing injustice to him. 167(2) is a statutory right. If you don't file the charge sheet, if he is in the custody within the stipulated time frame, he is entitled to be released. It is not under the grace of anything. By right, he has to come out. You have admitted that you have filed the charge sheet on 181st day, 1 day after the statutory period. It is also admitted by you that you have not sought for any extension. I put a question to you. If the on 1/8th day, 1/80th day, if he moves an application, he is entitled because he was in custody. 24th in his behind his back on Saturday, you file it. 25th was a Sunday. 26th, first available opportunity, he moved the application. The contrary judgment is, therefore I told you to just check it up in the afternoon, check it. It says that if 167 benefit is granted to someone on the last day when application is moved, but he is not able So here is a case
have elapsed and no petition was filed by me to hold the and no petition was filed by me to hold the present case to be a counter case. Whereas the law is that it is for the court himself to find out which is a case and which is a counter case.
Yes.
And admittedly, this is counter case to the other case.
Lordship also notice was issued, somebody has entered appearance in this case, Lordship.
Yeah.
The private company is there.
Who is entered? For opposite party?
Yes, your Lordship.
Are you ready now?
Yes, your Lordship. That is the case and counter case, your Lordship. Here is the present person is involved in 302, your Lordship. My learned is praying to the case, counter case, which has come to the case which is pending, the case before the learned census. That is the prayer. That was rejected, Lordship.
Yes.
That is not a challenge, your Lordship. My responsibility, Lordship, the case is present person is charged and charging failed with 2. Whereas the other counter case has been the other counter case is there is the offense which was not in the tribal by all the Lordship, that is magistrate Lordship.
That is the reason he is asking.
Yes, yes, that is there, Lordship. That is page relevant page is page 12, Lordship.
Have you seen the law point? On facts, you maybe
Yes, sir.
law point. Have you seen?
Very fair. Regarding
You have not seen the law point,
Yes, sir.
which is raising. Just this is
yes,
look into it.
Yes.
Non-APS for opposite party number 2, despite service. The counsel for the state seeks an adjournment to prepare the case. Beats the matter on so interim order pass on
That is passed on
24/7/2024. 24/7/2024. Shall continue. Shall continue. Shall continue. Yes.
May I pray for an urgent copy?
Yes. Yes, sir.
The petitioner here was convicted by the London District on section 138 of the NIT.
Yes.
And directed to undergo imprisonment. But against that conviction, we have prepared an appeal to the applicant. During appeal, he filed application on section 391 in the old CRPC, presently it is 450. Produce additional evidence. 2 documents he wanted to adduce. One is a statement of the bank showing that such a check was never issued, and other is a reply to the 138 notice. These two, these two things are.
No, reply to 138 notice must be there on record.
No, that is complainant has not filed it. Though he admits in the judgment, for achieving the judgment, he admits that there is a reply, kindly see.
Yes.
That is at page.
What prevented you to bring it on record?
Yes, it could not.
Huh?
I must admit it, it could not.
In your defense, you could have done it.
Kindly see, yes, it could
Yes.
have been. Page
Yes.
24, the Lordship.
24.
It could have been.
Yes.
I'll have to accept that. Page 24.
Yes.
Bottom 4 lines.
24. Yes. Yes.
During course of argument.
Huh? Yes. Yes.
Learned counsel for the complainant pointed out that the accused had in fact replied to the demand notice sent by the complainant, denying correctness of the demand, and as such he did not make any payment of the check. So question of my giving a reply is that the question, but document was not there. Neither they have filed it, nor we could also bring it in our defense. Though that is one aspect of the case, your lordship can attribute negligence on the part of the but the second issue is again that non-issuance of check again is a very important piece of defense on the part of the accused. That he has been saying in the 313 stage also, such a plea was taken. It's not as if it's for the first time.
If you have taken a plea in 313,
Taken.
what prevented you from leading defense evidence in these kind of situations? It is a complaint case after all. It is not a state case.
I can appreciate that.
Unless you satisfy that,
Yes.
I can't, a well-reasoned judgment, I can't set aside and put everything to, back.
Or well reasoned. So lordship will see the
Whatever there is, then in appeal you can very well point out those things. But unless you have to demonstrate what prevented you from leading defense evidence. Because these are the cases, 138 cases, time-bound directions, time-bound statutory command is you have to complete it. After you being convicted, the presumption of innocence goes, unless you make out a strong case that what prevented you from leading the defense evidence, having taken a stand in 313. It can't be allowed. 313 you have taken a stand. Why have you taken a stand then? Unless it is a rebuttable presumption. 139 presumption operates against you. It is a rebuttable presumption.
I can appreciate your lordship stand, my lord. I know your lordship.
The only thing I can suggest you is settle.
But I can only demonstrate from the order passed by the London Appellate Court that it is wrong on the face of it.
Then the appellate court will see it.
Yes, the appellate court's order is under charge.
Where is that appellate court? The application which you know. Show me the application. Show me the application. Application. Show me the application. The best thing would be I'll repeat both. And you need not pay interim compensation, argue the matter.
I have the right. Unless I'm considered my.
And he has a valuable certificate also, 140.
143 is a statutory requirement. One file, 20% of the defaulted amount is deported.
I'll
And on
satisfy that
the
order.
same, the same
I'll
to release-
satisfy that order also. I'll give you an option of moving a fresh application.
That's it.
It is unwritten order. I'll satisfy it. And I'll satisfy he did that order also.
Yes.
I'll give, let it be done
Let
a
the
fresh.
justice be done.
First matter, right? Petitioner is aggrieved by the order dated 17/5/2024, passed by, passed by, the decision says no appeal in criminal appeal number 16 of 2023, whereby his application under section 91, 391 CRPC has been rejected. Mr. Professor, the senior counsel at the outset submits that the application moved by the petitioner under section 391 CRPC is not happily awarded, and the appropriate reasons have not been given. Nevertheless, the trial court, while rejecting the application, has not assigned any adequate reason. He has relied upon a judgment of the Supreme Court passed in criminal appeal number 148 of 2019 regarding the Surjit Singh versus State of UP, and drawn my attention to para 15 of the said judgment. 15 and 16 of the said judgment. So further submits that in view of the settled position of law, the High Court ought to have dealt with the application under section 391 moved by the petitioner in accordance with the law, and dispose of the same by giving adequate reason. In the absence of reason, the impugn order is bad in law. Therefore, I have gone through the. Yeah. Yes, I have gone through the.
Disposing of the matter, discussion can observe that party is the liberty to negotiate.
I'll just
before the DLSN,
I'll just gone through the document placed before the court. Court and the law operating in the field. And I want to consider view that the impugn order, by which the application has been rejected is not well reasoned, and the same is satisfied. The petitioner is given liberty to move check fresh application. Fresh application to put the appellate court, which the same shall be dealt with the appellate court in accordance with the law. Now the material available on record. Having said that, I am also of the opinion that the appellate court may also explore the possibility of settlement through a mediation process. Both the counsel appearing for the parties are also of the similar view. before proceeding with the appeal, the appellate court is expected to explore the possibility of a settlement in the present matter. Insofar as next the diagram next the petitioner and the petitioner is the complainant before the court below in the 1 CC case number so and so initiated by him under section 138 NI against the opposite party. Divide a judgment the learned HDG on Noapada, while its judgment dated 4/9/2023 has convicted the opposite party for the offence under section 138 NIA and pass sentence on that count or pass a sentence on that count.
Array for 1 year.
Opposite party.
Array for 1 or fine will be 7 lakhs.
Array
Array for
of
1 year and fine will be 7 lakhs.
1 year
And fine will be 7 lakhs.
fine up to be 7 lakhs. The opposite party had filed an appeal against the same before the
District and
Sessions
Sessions
Court, being criminal appeal number 16 up to 2023. In the said appeal, the petitioner had moved an application under section 148 capital A
148.3
148.3
of the NI Act.
capital 148.3 of NI Act. The trial court, the appellate court has rejected the said application by the impugn order dated 14/11/2023. Isn't it?
No, 28/2, my lord.
28/2/2023. Even the said impugn order, the said impugn order is benefit of any reason, benefit of any reason. Hence, I'm inclined to set aside the order dated 28/2/2024 passed by the Journal District and Sessions Judge Noapada in criminal appeal number 16 of 2023 and remit the back matter to pass fresh order on the said application by affording opportunity to both the parties. Next one. And the it is worthwhile to mention that in the connected matters being CRLMC number 2427 of 2024, this court has already directed the appellate court to explore the possibility of a settlement before proceeding with the matter. With this observation, both yes. I'll come after lunch.
54 maybe taken about 330 kilo. Because I have some other.
Sorry? Yes? 59 at there, yes. Entry mode to continue.
Item 47, my lord.
47, okay, 47 also.
Enter in order to be continued.
Yes. Entry mode to yes, sir. 1 minute. Yes. 55.
Should we to hear that matter? Why 65? 64. Last matter.
Last matter. And who is for the other side?
Vigilance.
Vigilance, who is it? Yes.
Suspension of sentence was read for and you have told that I will hear this matter.
Yes. Who is appearing for vigilance?
Mr. Das.
Is he available? Just ask if it's possible, then we can spend little time here. Otherwise, unnecessarily he'll get stuck. Please ask him and inform him so that he will not unnecessarily meet.
I have urgency because you have told that I have not time in order and I will hear.
I see the same amount of hearing will take place. So it's better that we will just put upon appeal. This way or that way.
63, item 63.
64.
Just ask Mr. Sanjay Das There is waiting. If he will come, then we will proceed. If he's not there, then.
My lord, Mr. Das is mentioning about 62 and 63.
No, that I know, but no.
About him, yes.
He's
63.
Sanjay.
63 supplementary my lord has already had. Main accused has died and abated. This is a patent matter. This is covered in CRM.
Which one?
63.
1 minute. We are in some.
Can it be? Mr. Das.
By that time, my service would be gone.
Monday.
Okay, because unnecessary, I don't want
Yes,
that he should be detained.
Waiting, yes.
But I am much better than your lordship. Your lordship is sneezing and sitting.
I don't want to transmit it to you. That's
Spite of being ill, your lordship is also sitting.
Yes, Mr. Das is there. Yes, Mr. Sanjay Das.
Yes.
Are you ready for that matter?
Yeah, let them argue. I will just reply on the next day. Yeah, I will be present at the time.
No. Don't do that. Don't do that. Either.
I
No, piecemeal.
When my lord and respected senior will argue, I will remain physically present.
That is the same thing. It doesn't play it.
It is a response of let my lord and respected senior argue. I will be physically present after lunch. Let him argue. On the next day, I will finish my argument.
No, not there. No. Today, if you are ready, then we'll proceed. Otherwise, no piecemeal. He will argue thereafter you argue.
I pray that let them finish their argument. I will just reply. If your lordship permits, I will reply on the next day, next week.
Today you will reply, then I'll.
Monday or
I pray that after lunch, I will remain physically present before your lordship. Just now I am going. I will remain present. Let my lord and respected senior argue the matter. And after hearing, I will prepare my report. I will solve this. I will reply and solve it. I will just read my written note of argument. I will solve this.
No, I will not hear piecemeal. You should come fully prepared so that I can finish it up. She tried to appreciate one thing. He has moved an application for staying the conviction. And he's running around because he want to save the job of the appellant. And I said that instead of hearing the application, it is better that we will hear spiel and finish it up.
Yes.
Because same amount of time will take.
My lord, I am ready partly because it is a matter of 25. Your lordship has adjourned 3 matters of 16. I am
3:30.
I am what
3:30 so that. Yes.
Your lordship,
We understood.
Your lordship,
We understood. Thank you. We understood. Thank you very much.
Yesterday, Mr. Lawrence, Senior Advocate Jaswant Das matters were there.
It's all right.
Matter, your lordship of hard part. So it is burden job, my lord. So I will have to prepare.
All right. We understood it. Yes. Next.
Madam, item 63, my lord. Main accused has abated and trial against him is already abated. Challenge the order passed by the authority of challenge. It was pattern. It was covered by this Srimati Birajin Ponda. My friend is there on Tuesday. I played Tuesday.
Easy covered by the
yes. It has pattern Tuesday. Tuesday. 48.
My lord's item 48. We are entering appearance for opposite parties 1 to 3.
48?
Yes. My lord's
48. So entered appearance.
My lord, 48. My lord, I am petitioner in 48, my lord. My lord, let the matter be heard today, my lord.
Okay, wait.
My lord, 49.
Wait.
49 also.
Wait, madam. There is an opposition.
49 also at 3:30 p.m. I have cases.
49.
Put to 3:30. 49 also.
No, not immediately after lunch.
I will not be there because Passover already in court number 6.
Do it and come.
My lord.
No problem.
Your lordship is not sitting after lunch.
No, I'll sit. Because whoever wants an adjournment, I'm just.
Item 48.
48, I am appearing today.
I need to,
But
yes,
they-
I got a brief.
There is an opposition.
Yes, Lord, I got the brief yesterday, so I need certain.
Is there an interim order?
No interim order, it's dismissal of the petition where they want to take cognizance. It will take some time. And I pray to call this matter what next week or one half.
Yes, 48, who is it?
48, I am for the petitioner, my lord. After long.
No, they are entering appearance today. Mr. Mishra is entering appearance today. He is seeking a week's adjournment so that they will address.
London District and Session Judge Puri has rejected their application. Have come up. It will take time. They want to take cognizance where the section 197 is operating. They're all government officials. The executive engineer, the SDO, and all the accused persons, they are supposedly.
49, huh?
You also want to
Mr. 49, na?
48.
48. Mr. Lalit Mishra, Legal Counsel for entered appearance for opposite party number 2.
1, 2, and 3.
Opposite parties, huh?
Mal.
Parties, and seeks 1 week adjournment to file a counter to the petition. Let him do so within 1 week. Good to be put.
Grateful.
Yes, Lordship,
Item
here the
51.
matter, last item.
Item 51, my lord.
It will be hard
Item
today.
51, if I will taken up my lord, after loss, my lord, or tomorrow, my lord. I was on VC, my lord. I am in VC, my lord. If my lord, after lunch or tomorrow, physically, I will appear before your lordship. Item 51.
Which item?
Item 51. If my lord, tomorrow, I will physically appear before your lordship and argue this matter. Tomorrow.
Mr. Sudhi,
47?
can it be adjourned to
Interim order. Was compromised within the party. It said that so that they can appear physically.
What are the offenses?
Offense 360 507.
Okay.
Your lordship kindly direct.
Second week report. Second week.
Or they remain present in DC.
No problem. Let them.
That maybe.
I will not say this. I am allowing VC. Why should I record it? No. Which decision will not allow? It is meant for them. You just tell that this is the order, but I can't pass the order that you should appear and all because it is a kind of
Direction.
become party for settlement. I can't be out of court settlement. You come and
Fix up a date so that.
yes, and in the mobile also one can appear. Why are you going to the court? You appear log in your mobile.
File and discuss stay. Till that stay.
Then after lunch, let me see. You have a lot of things.
Complicated.
After lunch, yes.
I may be pardon, whether the matter will be hard today.
Thank you. Yes.
I am in virtual court. Item 40. I am
Yes.
Item 7.
Yes, when she's mentioning something. 40, pass on. Okay.
Item 7.
Wait, Mr. Pradhan, please wait. Your matter will be taken up. Please hold on. Yes.
Belgium Lordship, Emerald was issued on 14/11/2022. Date of release and bail 25/3. 25/3 Lordship that has been. Lordship paragraph.
No. The Union of India income tax something 5, na? 7. Okay. Yes.
7.
Give the dates. Bike से 12 2000 bike से नहीं bail, do you have the date?
That is Lordship, the present petitioner Lordship, not in bail Lordship.
Absconding.
Yes, Lordship. claiming parity is another co-accused religion B Lordship Jyotiranjan Nanda Lordship. That is Annexure 3 Lordship.
The petitioner on the request of the charge sheet has been filed showing the petitioner as an absconder, and on the request of IO, NBW has been issued by the order dated 22/12/2022 by the Lieutenant Session Judge cum Special Judge Sambalpur in PR case number 1 of 2019. Okay. Yes.
50. I have obtained the FIR and final form also. Effective 21.
Yes.
FIR was filed against the person.
Okay. Unknown, and what are the provisions? Yeah. The FIR was lodged where? Gola Thana. Acha, Golonthara. Golonthara, Barampur, huh?
Right.
And you are saying where? Kolahandi, right on. Petitioner has been raised as an accused in Golonthara PS case number 137 of 2018 for alleged commission of offence under section 279 /304 capital B. Both the offences are both the offences are bailable. Have you checked it?
Yes.
Both the offences are bailable. The petitioner is a resident of Kaland. He was apprehended in the aforementioned case. And was produced before the SDM Bhavani Patna on when was he produced?
15 to 25.
15 to 2025. The 15 to 25. The SDM Bhavani Patna on production of the petitioner before him has passed the following order. Full order record page 6. Page 6 order. Then counsel for the petitioner submits that under section 81 of CRPC bracket लिखियो 79 of BNSF. When an accused is produced before a magistrate for alleged of the offence for the offence alleged commission of offenses alleged commission of bailable offences under the proviso to section 81 CRPC, he should have been enlarged on bail by furnishing bond to and giving undertaking to appear before the concerned court. And he should have been enlarged on transit way. However, contrary to the provisions of law, the SDM Bhavani Patna has taken the petitioner into custody. Judicial custody. Hence, he has moved this application seeking setting aside of the order dated 15/2/2025 passed by SDM Bhavani Patna. I have perused the FIR, which has the counsel for the petitioner hands up for the copy of FIR which is taken on record, and I perused the FIR and impugn order, and in the light of proviso to section 81 of
80 subsection 81 subsection 1.
Subsection 1, the impugn order is not sustainable, hence I set aside the same. With accordingly, the CRLMC is also.
Yes. Extremely sorry, also item 7. The petitioner earlier approached bill number 68 paragraph 3 is mentioned. जो absconder कहले just charge it, but as released on bail, your lordship had ordered a bill number 1688/19, your lordship.
लिख दो ऊपर का 7 रे
Yes, your lordship.
dated
Dated, your lordship, that by Honorable High Court order, your lordship, that is 25/3/2019, your lordship. 25/3/2019 Honorable High Court bail release, your lordship.
Yes.
That the mean. But what happened he has mentioned on 24, but annualization 22. Therefore, I am confused. That
Item 18. May I say one more line may be added that SDM one Patna shall follow the provision.
Yes, I have set aside the ground has to follow. Yes.
Public.
Yes.
Not good.
And immediately go and move application and so that he can come out. Yes, sir.
May I beg your lordship, pardon me, Lord. I have some difficult because left ear is impaired by clogging.
Yes.
But
Yeah, he had a deep inside that Prayagraj.
your lordship, as per lordship's guideline, I went.
Adjourn it for other day. 8, huh? What do you want?
1818. 8 is
Because
your lordship allowed.
the case I was suggesting, this is the second visit of the petition, filing the second visit.
Yes.
You know, well, he's not
But
well.
he's not well, I'll not.
But he's quite blessed, lords.
So I'll just simply adjourn it.
No, I had the opportunity to have it.
Obliged. Thank you to my friend.
33.
Obliged.
May it please, your lordship. Item number 33. The matter was posted to 10th April. Now is said matter. My lord,
30?
previously, my lord.
What did he ask you?
My lord, what learned state council stating I am.
Is there an application for preponement?
No, my lord, may I submit, your lordship? Actually, this matter posted to 10th February, my lord, but inadvertently mentioned 10th April, my lord. Honorable Court directed to list this matter on 10th February, but somehow in the typo mistake there is mentioned 10th April.
Then how these matters come today?
Mentioned by mention.
That's what I'm asking.
By mention.
No, where is the application for?
501/20. I am number 501.
For early hearing, your lord.
Okay. Okay. Early hearing, for the reason stated in the application is allowed. The date of hearing is preponed to second week of March. 10th March. Okay. 10th March. Okay.
The notice already sufficient. OP2 already appeared. File counter. We also filed rejoinder. It is a
have you supplied
dispute.
the copy? No. Have
Copy
you
already
supplied the
supplied.
copy?
Yes, ma'am.
No, the application copy.
Yes, your lordship.
Otherwise, on 10th again it will be urgent.
No, my
You
lord.
will say that
He already submitted his counter, my lord.
I'm not saying that. Since the matter was urgent to 10th of April, seeking preponement, have you supplied the copy of preponement application to him or not?
Yes, your lordship. Yes, your lordship. I have supplied, my lord. The receipt also appended, also filed before this honorable court. That may be with the record.
This is
Gratefully,
an application moved by the petitioner for preponement of and the copy of which has already been supplied to the opposite parties for the reason stating the application is allowed. And they did prepone. Yes.
40.
Gratefully, lordship.
Yes. Yes, 40.
I'm for the opposite party number 1, your lordship.
Yes, Mr. Pradhan. Switch on your mobile.
Unmute करना थी वो कोई दूसरी.
Yes.
Yes.
Yes, I am difficult. I suffer from fever. Now I am recovered, but still I am in weak. I want a short adjournment that is a fixed date. A 10th or 11th April, it is shoot for me.
But they're enjoying the interim order since 2017, my lord. 138 NI Act matter.
So, this is 138 NI Act 2017 these matters are pending.
Yes, yes, I know. I only saw the 10th or 11th April.
It was
I
also listed at our instance. Opposite
Yes.
party. After the
And the last occasion I have said that it is made clear that no further adjournment shall be granted. That perhaps
because
the reason you have now been engaged.
at that time I was suffering also. At that time I was totally suffering from the fever. 10th April or 11th April, as you like. Man.
No, April, no question of April. I could think of next week. 17, 16 matter, and you have in 138 matter you have taken stay, and now see, no question of adjournment, sir. I'll put it because of your personal request. I'll put it.
March 12.
any
March
spot that
12.
the matter can be disposed of.
Yes.
The
March
very date
12.
it can be disposed of, your lordship.
But
Yes, sir,
he
this
said
was-
personal request.
No,
March-
on the next date. On the next date.
Mr. Anukul Pradhan. Mr.
Kindly
Anukul
March,
Pradhan.
kindly March
Senior
12.
counsel.
Okay,
Okay.
12
That is
March.
senior counsel. Okay. On on 11/2/2025, the matter was adjourned and a peremptory order was passed. Today, when the matter was called on the second call, the Mr. Anukul Pradhan, senior counsel, appears and submits that he is indisposed and therefore he may be accommodated for a week.
Or 12th
Regarding
March.
his submission, leaves the matter on 12th March. And it is made clear that
May pray that not on
if
12th
any adjournment is sought by the petitioner, the interim order earlier passed shall be automatically vacated.
May I pray that on 12th March I have some before that or after that, 11th or 13th, 12th March.
Okay, 13th March. Okay, 13th March. Okay.
Oblige yours.
Yes. Yes.
Item 50.
May I please, your lordship? Lordship, this is the application for on-sale of a residential house.
We have obtained an instruction from the concerned IIC. The case is under investigation, my lord.
What are you seeking?
Lord, I am seeking for on-sale of a residential house. The house is sold on 15.
But in a 482 proceeding, how can I do that?
My lord, in CRPC or also BNS, there is no provision for on-sale of residential. The 457 is containing the procedure followed by police or seizure on certain property. Hence, there is a sale. That's why I am filing the 482 application with you.
Then investigation is still going on.
Yes, your lordship, kindly for last occasion, the investigation officer has instructed the accused person are coordinated with the investigation. And the property is a immobile property. The petitioner is a senior citizen person, and the family member are also suffering to a very difficult to stay in the.
What are the offenses?
Offenses, my lord, is 318 for 347(1), 349. Read with
Not the corresponding IPC provision.
418 and 483, 486 and 34.
What are the allegations?
Allegation is that the accused person are manufacturing and selling the automobile duplicate automobiles product. And the manufacturing is not absolutely correct. The present petitioner is selling automobiles product. The GST certificate I have also attached on the annex.
I will not go into all these things. What are the you are producing Castrol duplicate?
Yes.
TVS,
Castrol, Golf,
Bajaj, Honda, Hero, and all. Therefore, it is sealed.
My lord, it's a residential house, my lord. My lord, the investigation is going on.
You are manufacturing duplicate thing and
no. My lord, manufacturing is not going on. He is only selling the product, and he has also.
Let them say that.
Yes. The investigation we have obtained instruction. Recently, the 4th February, we have.
Yeah, all these facts you are giving, why this premises is required for you? You have not
Because
said anything.
inside that premises, that residential house, they were manufacturing and.
That's right. You have sealed it. Now investigation is complete insofar as that part is concerned. Why do you need to continue with this? Why should you seal it? Now see, investigation is complete.
No, completed is on. Last sentence.
See, you can't seal the premises and keep on, in the name of investigation, you can't do that.
My lord, till now 7 months crossed. My lord, the petitioner is
Get
suffering very
instruction,
difficult.
whether it is required or not.
Yes.
Get instruction. Mr. Vishwal, although has obtained instruction from the IIT Tigdol regarding the matter, but nothing is forthcoming in the written instruction as to whether the premises which has been sealed is required for further investigation or not. Let him seek instruction, further instruction.
Let's sort that, man.
Yes. Next.
Please, Your Lordship.
Oh, blessed.
One serial number 49. Whether I am unable to understand whether that
49
is
क्या हुआ?
adjourned or sir, 49. Actually, I am appearing for OP number 2, Your Lordship.
What do you want?
Then already petitioner filed this this petition, and I am appearing OP number 2. If this the criminal petition is quashed, then the OP number 2 is not having any objection. In that regard, I am also I have filed one affidavit with that regard, Your Honor.
The criminal dispute, marriage dissolved and divorce.
Divorce, already divorced.
That means on the ground, the marriage has been dissolved and matter is settled. That is the ground. My reliance might have appeared OP2.
Have you filed wakalatnama?
Yes, sir, I have filed wakalatnama, and also I have filed one affidavit of that OP number 2 regarding this issue, Your Honor. Because the marriage is already annulled in the year 2015, sir. So the petitioner, I think someone appeared and mentioned in the
49,
morning
huh?
session.
Where?
49.
Wakalatnama again. What are the offenses?
That is Section 498A, 313, 506, 323, 406, 34 IPC and 4 DP Act. That is case 41.
There.
Mr. Mohinder Kumar Sahu, Satyanarayan Panda, Girish Kumar Satyanarayan.
For petitioner?
Mr. Basudeb Bujay.
Allow karo. Right on. At the instance of opposite party number 2, FIR number so and so came to be registered against the petitioner for alleged commission of offense under section so and so. The petitioner is seeking quashing of the entire criminal prosecution initiated against him by the opposite party. Notice was issued to the opposite party and opposite party number 2, so and so has entered appearance. So and so had an appearance. Mr. Mohinder Kumar Sahu, appearing for opposite party number 2, has submitted that he has on instruction he submits that he has no objection if the petition is allowed. He submits on the strength of the
One affidavit also filed.
he submits that the parties have settled their dispute before the civil judge, senior division, Kodola, Ganja, when the 1 minute, when MLT case number, HIT case number 5 of 2015 was pending before that court. The parties have entered into a settlement. A compromise petition was filed before the Court of Civil Judge Senior Division, Kodola. In the settlement term, it is inter alia agreed as under page 11 para 2, Purata, para 2. Para 2. Pursuant to the settlement term, when is the decree?
Decree also is that page 9. Page 9, you also.
Tell me the decree.
Yes, yes, also.
Pursuant to the settlement term, the marriage between the petitioner and opposite party number 2 has already been dissolved by judgment dated
28/6/2015.
sorry, tell me.
28/6/2015.
By which court?
Learned Civil Judge Senior Division, Kodola.
Divorce granted by mutual consent.
Marriage was annulled by that order. Marriage was annulled.
Marriage was annulled. Was annulled. Date marriage was annulled. On the basis of the same, the petitioner, the counsel for the petitioner submits that the present proceeding may be dropped. Since the petitioner, since the opposite party number 2 has no objection to the same, and he submits that the parties have already settled the dispute pursuant thereto, the divorce, the marriage between the petitioner and opposite party number 2 has already been annulled way back in 2015. I am inclined to allow the present petition. Moreover, the counsel for the state, Mr. Mohanty, submits that the dispute is arising out of a matrimonial discord. Parties have settled their dispute, which is germinating from the record, and it is also reflecting in the it is also reflecting in the judicial record. On the basis of which the petitioner is seeking quashing of the criminal prosecution, hence there is no legal impediment regarding head to the above record. Allowed. Yes.
Is Hon'Ble.
50.
50. 50 soila. 50 soila.
Right.
And 50 that soil.
52.
May I please? Last of the receipt on 11/2/25, director may take instruction regarding the status of the case, my lord. Yes. The case is pending, my lord, since 2005, my lord, for appearance of the petitioner, my lord.
Yes, have you got it?
We have sent the letter, but we have not got the instruction.
When have you sent it?
The lordship on 13/2, that's last week.
Pursuant to the order dated 11/2/2025, the State Council, Mr. Biswal, had addressed a letter to the concerned IIC,
IIC Jharsuguda Police Station.
IIC Jharsuguda Police Station to ascertain the exact status of the trial in the present case. However, he has not received any instruction as yet. Therefore, he seeks an adjournment. By way of last and final opportunity, 1 week is granted to the petitioner, opposite state, to obtain concrete, to obtain a specific instruction this in regard, and lease the matter on circumstances.
So also, my lord, the case diary may be available.
Okay, he may also obtain case diary of the case.
IA for us,
since the order was passed on 20 and 11/2/2025, and no instruction has yet been received, hence petitioner is granted liberty to move application for the trial court seeking an adjournment, and if such application is moved, same shall be considered favorable. Yes. Yes. Yes.
That case will also, I can remember that out of 9 cases, my lord, the police submitted a report that there is no evidence against the petitioners. So far, the 8 cases are concerned.
How many? 9 cases?
Yes, yes.
Yes. No, you have filed 9 cases now.
Yes.
In all the cases, the superintendent has said that no case is made out.
No cases. That is it.
Then why have you filed it?
No, they are kept, the investigation is kept open still today under section 170 clause 3. That is the whole difficulty. They are not exonerating the petitioner wholly. It is pending. And that
But it may be someone else. How do you know that they will ask you?
Your lordship, kindly see the report.
Yes.
Report, your lordship. That is why they were directed to take instructions.
Yes, Mr. Vishwal.
On the application of
and I'll tell you what is the fact. I tell you.
Yes.
This petitioner was implicated in 10 cases.
Yes.
He absconded. The wife of the petitioner wrote a letter to the superintendent of police saying that my husband is wrongly prosecuted in all this. The superintendent of police made an internal inquiry and find out that as many as in 8 cases he has been falsely implicated.
Yes. Yes.
Okay, 8 cases. And in 2 cases, FIR.
Only 1 case.
Sorry, 9 cases he have been. 1 case FIR was registered. Somehow he is facing that. That's a different story. In all the 9 cases, now 173(8) is kept open. Yes. What he says is, once it is kept open, and they are threatening the moment he will come out, one matter is registered against him and you are taken into custody. Why have you first, to begin with, why have you thrust 10 cases against someone where your own superintendent of police says that out of 10 cases, 9 cases are false? Why have you done that?
Your lordship, that the SP report, that is on 25th, 2023, my lord. We have got the charge sheet, supplementary charge sheet, final charge sheet on 4th May 2023. Where in that charge sheet, his name, the petitioner's name was.
Then the SP says that he was innocent, and the IIC implicate him again.
SP, actually, the additional SP of Jaipur has reported.
Then who is correct then? The IIC is correct, or the investigating officer is correct, or the senior officer is correct? Something very serious is happening. I tell you.
Yes,
you can't implicate. What is happening, I know. You recover 500 kilo of ganja for someone, and you implicate 5-6 people dividing that recovery.
May I pray one thing, my lord? Your lordship may call for a report from the SP because 2 officers are giving 2 separate opinions. So let him go through the CD and also the report of the, because he is
better. What you should do is you should call him.
Yes.
And ask him.
Yes.
Why are you creating this situation?
Yes. Keep it 2 chapter.
I'll keep it.
And
you should call and interrogate these people. Why do they do to the citizens like this?
Yes, my lord. I have read for status report of the cases, and I have wrote letter to the
connected
in this. Call him.
I'll call and I'll
call him to your office and ask what is this going on.
In charge sheet also you have to.
If that letter will be the part of investigation, man, then police officer may exonerate the charge sheet upon him and to close the.
But one of the officer has given a report in his favor. I don't know what exactly is happening.
That would be part of.
Right. By way of last and final opportunity, State Council is seeking an adjournment for obtaining instruction in all these matters. Least the matters, shall say, interim models that we have passed that can. Yes.
In all cases.
There's a copy of the order.
Copy of the order, your lord.
Yeah.
Very, very difficult.
Yes.
This thing.
That case, my lord.
40?
That case, my lord, where the public servant, the husband, expired, the petitioner is the wife, my lord. Last occasion, also direct also me and also my senior apparent of vigilance. When the police submitted charge sheet dispelling the income the property acquired in the name of the wife, my wife, can the case run against the wife under aid of 109, my lord? But your lordship, my lord, in the case of Ir Sonalata, that case, my lord, though the husband alive, but that case was on the ground that wife having no own suspended income and he has not abated. There is no question of abatement, my lord. 107 not complied.
Let us see what are the allegations against you.
Allegation, my lord.
What is your name? Your name is
Petitioner, my lord.
Kusum Munai.
My lord. What are the
Who is appearing? Mr. Das?
Mr. Das. Lordship already had this matter, but in fact, my lord, urgent for my request of my senior also me, my lord.
What do you say? You
If my lord friend relies on any judgment which endures to his benefit,
He Sonata case, my lord, square applicable discuss as because
no. See, that judgment ratio is something different.
That is, my lord, square applicable discuss.
no.
One thing, my lord, the petitioner stands better for
the moment the wife put forth his defense,
my lord,
he has to prove it in the trial.
My lord.
The benefit of my judgment will not be able to.
If another judgment, my lords, which may lend supports to my lord's law, let him come out that.
No, that judgment, my lord. What happened in that judgment?
But he is indicating something else.
That is true, my lord. But in that judgment, charge already framed, my lord. Here is a case, my lord, charge has not been framed. Before framing charge, husband expired. Public servant expired. So in case of charge framed, that is, petitioner has to face the trial, my lord. Here, my lord, is so far two contingents, my lord. One is 109 cannot run alone. Aid up 109, 13B, my lord, against the husband. 109 against the wife, my lord. In the absence of a husband, my lord, the public servant, the case can run against the non-public servant. That is one thing. Second thing, my lord, in order to fulfill the offense under section 109, they have to, the IO has to, my lord, substantiate 107 of the IPs, my lord. Here, my lord, that has been not done, my lord. Question of abatement does not arise. And in the charge sheet, my lord, page 36, specifically, my lord, the IO while submitting his wife, Srimati, the petitioner, Kusuma Naik, being the wife, having no income, acquire asset in the name, in her name, and so she abated her husband in abated, my lord. What is the question of abatement, my lord? They, while somebody charge sheet specifically stated that the wife having no income, acquire assets. So, my lord,
yes,
it is presumed that the entire, my lord, property belongs to the husband, my lord. Nothing in the name of the wife. As per 36, my lord, first paragraph.
Come to 109, Mr. Das. Come to 109.
Your lordship,
very interesting reading. 109, just see. It says, whoever abates any offense shall give a gap now. Now you read. If the act is abated, is committed in consequence. So you have to prove that the act for which he has been abated, that act has already been done. If that act is not, you can't prove the act, whether the act is done or not, because the offender has died. Then where is the question of abatement? Just read the sentence full. Just see, whoever abates any offense shall, if the act abated is the offense, is committed in consequence of the abatement. The act abated is the PC Act. That has to be committed. You say it is committed, but you have to prove it on record that it is committed. But you can't prove it today because he is no more there. Then how will you bring abatement?
Starts submitting the grounds available for me. Ultimately, when the two big elephants fights, go classes under their feet, they only survive. So what I suggest, whatever the motion is put for that particular population, my lord friend should come up with that That,
No, you need not go into judgment. You can read the very simple this thing.
but that point will also, there is a judgment of this.
Come to 107 again. You read it. A person awaits the doing of a thing who first condition instigate any person to do that thing. Which person? What thing? How will you prove it? If that thing is proved, then only abatement proves. That you can't prove because the offender has died. The offender has died. Where is the question of proving? You can't prove. If you can't prove, there is no question of abatement. And intentionally, third is very important. Intentionally aids by an act or illegal omission doing of that thing. So doing of that thing means the real offense. Real offense by the real offender. So I don't think you can improve upon your case. Think over now.
You should think of.
I am giving this judgment, your lordship judgment, and your lordship reserve the my lord. Bas. And with
And 108 is again justice. 108 justice. 108 justice. Who is an abater?
108.
Who is an abater? Abater is a person await an offense, who awaits either the commission of an offense, you have to prove the commission of offense, or the commission of an act which would be an offense if committed by a person. So the commission of offense has to be proved in order to bring it, which perhaps you can't prove because the person who has committed the offense has already died.
This proposition was also another page this case how in that judgment matter has gone. I was the counsel. This particular the facet of this proposition was not in what you're saying. That was I thought argued against.
Crime has to be proved to prove the abatement. The crime you can't prove because the person who has committed the crime has died.
My learned friend should be equipped with better weapons.
no. More than lordship judgment.
I have sympathy for
Is Sonalta my lord case is lordship.
No,
Very good judgment, my lord.
But that is in a different pedestal.
No, my lord. Exactly same, my lord. Page 36.
No, I have dealt with 107 now.
Exactly. Page 36, my lord, very clear. His wife, Srimati Kusuma Nayak, being a housewife, having no income acquire asset in her name.
Okay, that's why
If she claims prosecution bring out evidence that she has income, other things, my lord, then only, my lord, she has to face the
whether she is justified. Justified. She is not even justified.
Not justified. And for that in chassis submitted, his wife, Srimati Kusuma Nayak, being a housewife, having no income acquires assets in her name. As such, she abated her husband. That is, my lord. Only when she has not acquired anything, my lord, for that is abated. Question number, nobody stated that. Nothing is in the record, man, that the petition abated, my lord. With regard to abatement, there is no such, my lord, the material available in entire record, my lord. In the chassis and
judgment to substantiate your please.
My lord, judgment, better judgment.
Difference solno pura lagiboni.
Na lagio. Solno ta case lagio. 107 clearly age. I had given judgment. Na, it's nice.
He knows that. Raju, he knows that.
No, page 33. Sornota will not help you. Page 33. Income tax return justice.
That has been dispelled by the prosecution agency. For that reason, my lord, they have stated in paragraph 36, my lord. That is my case, my lord.
You have produced the fictitious.
They have not believed that, my lord. They stated that there is a fake one, my lord. So, my lord, that is no question of, my lord, own such in court does not arise, my lord. That is in my lord, the charge sheet in page 36. They have specifically stated the wife Srimati
Oh, that
Sonalata
is not taken into account at all.
account, my lord. That is the case, my lord. So the Sonalata case applicable.
Lordship turn to the last portion of the same page 33.
Yes.
One double storage.
Ye widow lady, my lord.
Everything is all right, but he tried to give income tax to say that I have some income. You didn't believe.
Didn't believe.
You have thrown it out.
So now they stated that no source of
We have taken
income.
consideration.
But that is
but,
not.
attach-
That is the cross of the case on the last occasion, Lordship.
Judgment lekha hua
Judgment is a
Okay,
My lord.
long and short of the matter is he seeking adjournment.
Lordship, these are better.
So first week.
Say pointer tha.
Okay,
Say pointer tha. We'll
But
come back.
here, this is a good matter to be, we can deal with all this. Yes.
What is the result?
Okay, sixth. Sixth.
Reserve kar lijiye.
Yes. No, he will give the judgment. Written note you give, both of you.
My lord.
Both of you give. Get written note, I will not hear. I'll just reserve on that.
Obliged.
Yes.
State, my lord, interim content.
Interim note to continue.
What your lordship said, put for the proposition is come up with the to substantiate.
He'll file a written note. I heard it.
After all, my lord, the old lady, my lord, who has to face the trial, that is, my lord, the
So far, I'm silent because of the only one and studying.
The husband died. Otherwise, also you have no case. You can't prove.
That is another.
Wastage of time.
But old lady is there.
But a wastage of time. You don't have a case at all. Simple.
my friend, my lord, senior, very much
No, merit is that at least four. I am equipped with four judges.
Now, how will you prove the commission of offense? If you can't prove the commission of offense, where is the question of abatement? He's straight away out. By reading up 107, 108, 109, plain reading, he's out. Forget about the income tax and all, that Isarnalata and all. Even if you leave that part, he's out. Check it up and give it a note. Yes.
This is
three cases are there, madam.
Yes.
Arising out of one issue, 3 FIRs have been logged, 4 FIRs have been logged.
Yes.
One FIR has already been charge sheet has submitted and it is passed by the solicitor. The present petitioner, he has been implicated in this case without any basis, my lord. The lordship, your lordship has passed the one judgment, my lord, in favor of the Prahakarna, where your lordship can see the gist of the case, my lord. The
It's coming the first time that notice go.
notice your lordship can see the Anissa 7th judgment I have given.
She put in. Upon a copy at the simply
Lordship total covered by this.
just keep him.
Arising out of one.
He may say so that. Yes. Yes. Next.
Need a time for that.
Mind applying equally to how हमारे ठीक होगा
Or hearing matter.
Socket, my lord, is power.
Judgment कहाँ थी?
Short date. Judgment at the
And it's a step.
we should ये matter ना पिन तक
Is 50.
settle better तो कोई settle any settlement
758.
any matter which is settled already
56.
hearing matter I will not take it up only matter settled then
61 is not settled, it is okay.
then I will hear it later on.
Yes.
I'll give it
Fresh matter. 61 is a fresh matter.
Annexure 7
61 notice कर दिया 61 notice कर दिया notice to opposite parties. Okay.
I also notice.
I notice कर दिया both.
It's the infringement matter, so date may be fixed.
हाँ date will be fixed. Don't worry. Yes sir.
167
हाँ one yes.
72.
हाँ.
Here in this case, if you was 100,
24, I'm submitting. 124, 124.
I know remember right.
121 days, my lord, charge was filed.
Thereafter.
181 day.
81 days.
Yes.
On the next day, he has filed on the 7th day, he has filed the case. And question arises whether that is the deferred file investigable or not, because 2 days are 40 days prior to that.
Yes.
Submission. My humble submission to Lord says, once the charge has been filed by the court, by the prosecution matter, then 167 will not apply.
160. Yes.
In absence, I was not there. That is the problem. I was not produced on that day.
He's in custody. How will you know? How will you know? He's in custody. You don't put him to notice.
Notice was given to
And behind his back, you file charges. And next day, Sunday. And Monday morning, he filed an application.
Your Lordship will otherwise also take it to consider on that aspect, my lord.
No, what is the law? Don't.
Law is once the charge has been filed, my lord. There is filed and verification is not better. My humble submission to that the today I have not.
So midnight, if you come and throw this thing, the right goes. That's what you are saying. I can understand. On 1/8 day, they had to move an application. Okay? And next day you have filed it. Next day. And he was in custody.
No, that was Sunday.
He was in your custody. Was it not your duty to tell him? Under judicial custody. Today it was filed or today is not filed. And today is the last day of filing. They are not filed. Is it not necessary?
Once charge is submitted.
Ground, you just see the ground reality.
Thereafter, there is a difference there. So he knows that charge has been submitted.
That was not the date to which it was posted. No, that is not. That was not the date to which it was posted. It was posted to next Monday.
Time law inspector decidable.
Do you have a judgment to that effect?
If a lordship permits me not submit one thing.
I'll tell you, these are the liberty matters. You can't. One day also somebody. Why should somebody? Let us see one.
When actually he has come all the way from Prayagraj, not gone to house on. This case. Very simple. Se ghar ko bhi jayenge 840. Mr. Jena has come to this court. No, I will not argue. I am also not arguing. मैंने घर को जाए नहीं कोर्ट को चले ऐसे डायरेक्ट पैराग्राफ स्टेशन
That was although the copy is not with me because of for that I will excuse for that. In that Supreme Court judgment also stated.
I know that you are saying that once 167(2) benefit is given, but unfortunately he could not file the bail bond.
Yes.
By that time, a charge sheet is filed, and subsequently he produces bail bond. Court says that you lost your right. Because charge sheet is now filed.
Here in this
is the judgment.
Yes.
I don't know the citation, but there is a judgment. Straightforward. Once you have to assert your right, and bail was granted to you, you did not avail. Therefore, the right goes. But here is a case, he has not moved application.
The dates are very clear, madam.
And there is a reason of not moving application. So he is availing the right in the right time. And after availing the right, if the right is bestowed upon you, if he doesn't avail of it by filing bail bond, then in that case you can very well say that no, it was given to you, you didn't take, so remain in the custody.
Well, the dates are very clear in this case.
Dates are clear, I know. I'm just. Do you have the judgment? I'll put it tomorrow. Monday. Get the judgment. There is a thin distinction. In any case, they are spending money to keep you inside. Sir is saying something.
Public money.
Public money. They are feeding you. They are keeping you inside. Yes. Thank you.